Okay. I have one. Oh. Well, when I
Oh, I see what you're saying. That's insane.
Yeah, it was a whole different thing. I'd like to call this meeting to order, the February 6th meeting of the Sunshine Ordinance Task Force. Madam Clerk, will you do roll call?
Member Nee absent. Member Monet.
Here.
Monet present. Washburn.
Present.
Pilpel. Member Pilpel absent. Member Sims. Member Sims absent. Member David.
Present.
Member David present. Member Highland.
Present.
Member Highland present. Member Oka. Present. Member Oka present. Member Fisher.
Present.
Member Fisher present. Member Grant.
Present.
Chair, do you have a quorum?
Great. We had an excused absence from Member Nee, who let us know that last meeting, correct? Yes. And then Member Pilpel has called and is.
He's the flu.
And then Member Sims is running late.
So he'll be here.
Oh. Member Washburn?
It's been, although we've been criticized for this, it's been our pattern to move that members be excused if in instances like Member Nee and Member Pilpel. So I'd like to move that these two members, that their absences be excused.
Seconded.
It has been moved and seconded. Clerk, Madam Clerk. I'm taking over your.
Well, you're good.
Okay.
Do we need public comment? I don't know.
Yes, right. Is there any public comment about these roll call issues? If not, then we will move forward. The next item are any agenda changes.
I'm sorry, point of order. I think we need to vote.
Oh, I'm sorry.
That's okay, too. Excuse
to
the
vote.
absences.
Oh, yes, I'm
You can
sorry.
probably take
There's
it
a
without
motion on the floor.
objection, right?
Yes. Does it look like anyone's going to disagree? If not, then I would like to pass this without objection, that the members are excused. Okay, let me move on to agenda changes. First of all, I need to, by a show of hands, just see if the respondent and the complainant are here for some of these cases that we're about to hear. File number 11068. Is the complainant here? Okay. Is the respondent? Is someone from the planning department here? I'm sorry. I can't see. Okay. Thank you. File number 12034. The complainant had sent a letter indicating that he had to be absent and asked that this matter be continued today, and I believe he informed Susanna from the film. It was forwarded to her. Is Susanna here? Okay, so you were forwarded this email that he was going to be absent today because of an illness in his family? Okay, great. So
Does that mean that nothing gets spoken about this?
Well, we can vote to continue this. He had asked that we continue, and that's why we sent that email to you to let you know that he would not be attending. So it would just be your perspective. We won't hear his side. So that would be the problem with that. So that's kind of where we were. If we were going to continue the matter, was that not made clear?
No, as a matter of fact, I called the SOTF office.
Can you come to the mic? I'm sorry.
I'm sorry. I actually called the office, the SOTF office, to kind of get
You
clarity.
spoke to
on that.
Andrea, correct?
Oh, Andrea, hi. And I'm sorry, I still wasn't clear that this was an automatic continuance. I thought there was going to be still discussion about the whole issue, because we did provide the documents he needed, and Debbie's here to talk about it.
Jerry?
Madam Chair, with a request for continuance, the agenda item is called, and then a motion can be made to continue the item or not made, but absent a motion to continue, which has to be seconded and voted on, and then there's discussion about it, the item would remain on the agenda. So there does have to be an action by the task force. It's not an automatic continuance.
Exactly. So we do need to vote on it. I just was letting you know, and that you should have gotten correspondence that had been forwarded from the clerk. So I wanted to be clear that you have that. And then we will open it up for a discussion, but that's just to let you know that as an agenda item.
So can I just ask one question, just so I'm clear? If you vote to continue it,
It will go onto the agenda for next month.
and nothing can be said about it today then, at all? Nothing that Debbie has prepared to say, or,
No.
no?
Sorry.
Okay.
Member David?
I do have a question to Deputy City Attorney Threed. Basically, what what was just asked, is it possible for us to hear from the side that is here and hear what they have to say? And then do we have an opportunity, could we, after hearing that, choose to continue it if we wanted to?
Through the chair to Member David, you may proceed that way. It's somewhat irregular for several reasons. You'll be hearing from one side who hasn't had the opportunity to hear the case that will be presented by the complainant, and therefore will in some ways be at the disadvantage of not knowing what to respond to. Nevertheless, they will present their side without the corresponding balance of hearing the complainant's side. So that can form an impression in the task force members that will last until the next month and could influence the way they think about the matter. So it's not prohibited. I would say it's not advised.
Thank you.
Great, thank you. I just want to clarify, to go back for a second, file number 11068, anonymous, is here, I believe. Okay, great, thanks. So we have file number 12034. I also want to see if the Clark brothers for file number 12038, if they're in attendance? Okay, thank you. And is Ben Rosenfeld or representative for the Arts Commission here?
Controller. The controller.
Controller? Controller for, is the controller here? No?
Have time still.
Okay. And is Monique Zamuda, the assistant controller here? File number 12039? Just raise your hand if you are. Okay. For file number 12040, anonymous versus against Robert Collins, Deputy Director for the Rent Board. Are both parties here? Okay, great, thanks. Robert Collins, you're here, right? Okay, thanks. File number 12041, anonymous against the Human Rights Commission. Is there a thank you. And anonymous is here. And file number 12042, anonymous against Lupe Areola, discrimination investigator, human rights. Oh, okay, thank you.
Are they both here?
They're here. Okay, great. So the agenda change, one of the first ones that we had was a request by, Madam Clerk, do you have that request to move cases for anonymous up? If you could read that to, do I have it? Got it. Do you want to read it? So we have a request from Anonymous to move, the Anonymous for file number, and correct me if I'm wrong, Madam Clerk, file number 12040, file 12041, and file 12042 to be moved up under the ADA section, requesting reasonable accommodation. Just to give you guys a heads up, so we can decide if we'd like to move those up. And then file number, as I mentioned before, 12034, he had asked for us to continue that case because he's absent. And against the Film Commission. So those are the two agenda changes that we need to discuss. So I'm opening up. So if we'd like to make a motion to, one, move the cases 12041, but now, 12041, 12040 through 12042 up to accommodate the disability issue of anonymous in those cases. I need to get a motion. There's two anonymous. There's two anonymous today. So these last three cases is what she wants to move up. Note that the first anonymous has file number 11068. That's the same person. And then file number 12034 is what we decide. If we decide to continue, that will be off the agenda item for today. So all we'll be really moving is 12040 before two cases. She will have been heard the first case, and then we will hear two cases, and then if we decide to do what she's asking us, we will move those above. So,
This was an accommodation for a disability.
a disability. So, I need to have a motion.
I'll make that motion.
Okay.
I'm so moved. I make the motion that we move up to accommodate a disability, that we move up file number 12040?
Through 12042.
Through 12042.
To
Come after, is it 11068?
068. Do I have is there a second? It's been moved and seconded.
Need to vote.
Yeah, I have to take public comment first.
Comment before we vote?
Yeah. Is there any public comment? Thank you. This is one.
Good evening, members. I'm William J. Clark, and I'm objecting to you moving this up in front of me. Although I sympathize with the disabled, this is a very short calendar. My two items shouldn't take very long, and I'm 66 years old, and my brother's 66 years old, and I'm tired, and I've been waiting, and I think I can get through my two items relatively fast, and I respect your wishes, but I please ask you, just let's go ahead with the calendar as quickly as we can. Thank you.
Thank you.
What were your items, Mr. Clark? What items?
His items are number...
You're number 4 on our list.
Four and 6.
4 and 6, okay.
Is there any more public comment?
Hi, I'm Robert Clark, and I'm kind of redundant all the time, so I hope you can appreciate that. Again, I want to say that unusually short calendar tonight, and your first two calendar items sounds like they're going to be fairly fast. And since the controller and his worker aren't here tonight, I think we can get through our two items extremely fast. At least we're going to try to do that. And so, with further ado, I object to the motion and would just like to go through the regular calendar.
Can I withdraw?
Is there any more public comment?
I've been swayed.
Task Force members, Ray Hartz, Director, San Francisco Open Government, and I might just bring up the point that the person asking to move up the hearing on the agenda might be well advised to wait and see if they get more of the Task Force members here. Because as it is, they have to get a supermajority of the votes present to win. In other words, you've got 7 members, they've got to get 6 votes, which is, again, coming back to what we had with the past problem with this task force, and that was having so few members show up on a consistent basis that you went to the simple majority rule, which the Board of Supervisors then removed a bunch of members from the task force.
Thank you, sir. I appreciate it.
Well, why are you interrupting me, please?
Because I do believe that, is that what we're talking about, her...
I am talking about moving up the agenda. What I'm saying
Based
is she
upon
would
the-
be better advised to leave it where it is so that if you get more members, they won't have to have 6 out of 7 votes. Maybe they'll get 6 out of 8 or 6 out of 9, which is a lot more reasonable for a complainant to a burden of proof for them to meet than trying to get 6 out of 7 votes, which is unconscionable.
Thank you. Is there any more public comment?
I would like to leave the agenda as it stands. I know that the Clark brothers are old and they've been waiting patiently, so I would respect their wishes.
Thank you.
I would like to propose that the subject regarding Ms. Brubaker, actually, even though it may be unusual, that the task force hear the comments from the public before they vote whether or not to continue today, because many, many people took off work today to come give testimony because of the scheduling of this hearing. And just because the complainant is out of town, he actually was able to make comments, and the task force was able to hear from him directly last month. So it's not that his voice has not been heard. And the testimony of people who have shown up today who may not be able to come back again, that testimony would then be lost. So I would hope that at least the people who showed up today would have an opportunity to speak. And have it be relevant as to whether or not a continuation was voted on. Thank you.
Thank you.
Good afternoon, members of the task force. I'm anonymous, and I would like to request that my ADA request be withdrawn at this time, and thank you for considering it.
Thank you.
Through the chair, just a few comments. A request for accommodation, a reasonable accommodation under the ADA is a matter of some significance and not to be made for strategic reasons in a complaint. Anonymous presumably made the request because she has a disability that would make it difficult for her to wait through this meeting and then present her cases at the time that they were scheduled. To withdraw that request at the suggestion of a member of the public that was based on strategic voting considerations, I think may be weighed if this request is again made in another context by Anonymous.
Thank you. Sure.
Thank you. Given my history with the task force and given that some of these complaints are months old, I was not really sure as to how many of them were actually mine. And given that this is a short calendar, and I can see that perhaps it will move quickly and perhaps it will not, but there's nothing strategic about wanting to withdraw. Just because I'm disabled doesn't mean I cannot consider other people as well. So I am asking for the reasonable accommodation to be withdrawn at this time because we have a very short calendar for the record. And thank you.
Thank you.
How do I withdraw my motion?
So I don't think you have to do anything.
Right, we never voted on it. Okay.
So the next agenda change at this time is item file number 12034, which is, I'm sorry, what, yes? Is this public comment about what we were just talking? She just withdrew her motion, so we've moved. It's about 12034. Well, let me get through this first, and then we'll offer the opportunity for public comment. So if you can just hold on a second. File number 12034, and the request by the complainant to have this item continued to next month's meeting, March 6th. Do I have a motion about?
I have a point of order for City Attorney Threet. Would the members of the audience be able to comment on this case during general public comment?
If the item is continued and is not called and heard tonight, then it can be commented on at general public comment, because it will not be an item that has public comment otherwise.
Thank you. So I'd like to make a motion to continue this item until next month's meeting.
Do I have a second?
Second.
It's been moved and seconded to continue this item to next month's meeting. I'd like to open it up for public comment on this item.
This is on file number 12034, correct?
Mm-hmm.
Okay. I'm a filmmaker, and I just canceled an entire project to come down here and testify on behalf of Debbie Brubaker, because I have known her for decades, working in the film business in the Bay Area. And 75 or over 75% of the people in this room came down for Debbie to talk, and they've got projects. And by this guy just canceling it out at the last minute, a lot of us will not be able to show up to testify, and I do not think that is fair. It's a good maneuver on his part, but it's not fair, because I would like to have everybody talk on behalf of Debbie and Debbie defend herself here. You know, and by moving it up, sure, maybe Debbie will only be here next time because we all have to work. We all canceled everything today. 75% of the people here canceled our lives to be down here. That's my statement.
Okay. Is there any more public comment? No.
Task Force members, Ray Hartz, Director, San Francisco Open Government, and given DCA 3's comments, I would ask that he respond, or one of you ask him a question as to whether or not, if people make comments during general public comment today, whether those even have to be considered if the case is heard at a later date. My understanding of a lot of these issues is, number one, anybody who isn't here now would never hear those comments, and as a result would be denied the opportunity to include them in their deliberations. And number two, I've heard a lot of city bodies who said, well, you know, if you don't testify during the actual case hearing, then we don't have to consider anything you say. So, you know, saying, well, you can talk during general public comment may be a way to appease people, but I think someone needs to ask the DCA whether or not there's an obligation for those comments, if made today, to be considered next month, if that's when the case is heard.
Member Washburn?
Chair Yant, through the chair, DCA 3, what about Mr. Hart's concerns here?
Through the chair to Member Washburn, responding to Mr. I'm sorry, I'm having a Hartz. Sorry, Mr. Hartz. I usually remember your name. Any public comment on any item is not required to be considered by the members in making a determination on that item. What is required are the presentations of the parties and any facts provided in evidence by those who appear to support and provide those facts. That's why there is a category for that. So if someone has evidence that could weigh on the determination and sway it one way or the other and wants to present that, the time to present that is for the facts and evidence in support of a party member. So the status of it, whether the comment appears with the item as public comment or whether it appears in general public comment, has no effect one way or the other on that.
Member Washburn?
So it seems to me that, well, the way to proceed here, it's not a tidy way, but it's a way that will give us the most information, even though it's not coming all at once, would be to move forward with this item so that we can hear what the respondents have to say. Having the people who have come to present facts and evidence in support of the respondent making these comments during general public comment, they wouldn't have the same weight for us. So it's not the best way to proceed, but under the circumstances, it might be the wisest way to proceed.
Is there any more public comment?
If these people are filmmakers, they can videotape their testimony, and it can be shown at the proper time.
Thank you. I'd like to open up to the task force. Is there any conversation or anything about this? We have a motion. on-
Yeah, I mean, I don't think we have a great
Solution.
there's not a perfect choice in front of us, right? I mean, so I'm going to continue with my motion to, or I think I made the motion to
Continue.
hold it over till next month with my hope that the people who are here will give general public comment. I can't speak for the person who canceled at the last second as to why he did
Let me
that.
clear up something.
Yeah.
Anonymous did not cancel at the last second. He canceled on Friday, at which time our clerk forwarded that email to Suzanne, I believe, from the Film Commission. So it's not a last-minute thing. So I just want to be clear about that. And that's my concern about having just one side here presenting their case or side. And there were things that were discussed at the last meeting that they were supposed to kind of have moved forward on. And I appreciate everyone, taking off. I understand something went around to come and support Debbie. But I really want to make sure that we're clear that what we're trying to determine, our jurisdiction, is about the emails that were required, that he's asked for between Suzanne and Debbie. But he's not here to talk about that. So during public comment, that is when you can talk about that. And then when we hear this next month, we will then be able to open it. But we are more than happy to hear public comment during our general public comment in support of Debbie from everyone that took, because I appreciate that. And I know how work is, and I know how time is, so I appreciate that. So I definitely want to hear that. But I do think that it's not fair to hear from the other side that's not here today. So that's all that's about, pretty much. Member Washburn?
Right. Thanks for clarifying the issues here. This is an unusual case for us in that I think a lot of the energy and the advocacy have to do with issues that really are not under our jurisdiction.
Exactly.
Our jurisdiction is very narrow here and has to do with emails, public records. And so some of the other issues raised by the complainant against the respondent are not something that we can say anything about. So now I'm thinking that continuing this might be a better way to go.
Okay. Is there any more comment? If not, I'd like to take a vote. Can we take a roll call vote?
Member Monet?
Aye.
Monet, aye. Washburn?
Aye.
Washburn, aye. Sims?
Aye.
Sims, aye. David?
Aye.
David, aye. Highland?
Aye.
Highland, aye. Oka?
Aye.
Oka, aye. Fisher?
Aye.
Fisher, aye. Grant?
Aye.
You have 8 ayes.
Great, so it's been moved and seconded that we will continue file number 120342 next month. You guys, we will have public comment, which time you guys can speak to whichever you want to speak, supportive the film commissioner. Okay. Does anyone have any other agenda changes? If not, let's get started. Madam Clerk, can you read file number 11068?
Item number 2, file number 11068. Compliance and Amendments Committee has referred file number 11068, anonymous against the Planning Department, back to the task force for further action, including a recommendation to the Ethics Commission.
At this time, can we hear from the complainant, anonymous?
Good evening, Commissioners. I am very much in support that the recommendation to the Ethics Commission go forward. I think that given my experience and perhaps some of the newer members from the task force have seen some of the correspondence between the planning department and myself, and in the end, they never actually gave me what I was requesting, which was all of the documents in regards to the Park Merced project. And I do feel that they, in having done so, they violated the Sunshine Ordinance, blatantly so, and beginning with the executive director and all of the people that I was in communicating with, because they are all required to undergo Sunshine Ordinance training every year. So for this to have happened, it's really unspeakable, and it's unprofessional, and it violates the ordinance with the city. So they never gave me all of the documents as that now stands, and I think that was their intention all along. And 2 years later, I would just like to see this resolved, and I truly do think they should be recommended to the Ethics Commission.
Thank you. Is the respondent here?
Facts and evidence.
Oh, I'm sorry. Is there anyone, one second, is there any members of the public that are here to support Anonymous in this? Facts and evidence?
Task Force members, Ray Hartz, Director, San Francisco Government. If you notice by the number of the case, 11068, this is from 2011, so it's already been dragging on for a year and a half. And any more delay on this is unconscionable. You've gotten a response from the respondent that they're going to give, other than what they're going to pop up with now. And the bottom line, they've had plenty of time to either comply with the order of determination or to give a clear explanation, a lawful explanation as to why they wouldn't. So letting this drag on further is unreasonable for the complainant. She has waited long enough for this and should be given a prompt thing, because so far she's been denied due process of law.
Thank you. Any more facts and evidence in support of the complainant? If not, will the respondent from the Planning Commission? Planning Department? Sorry.
Hi, good afternoon.
Good afternoon.
I'm Tom DeSandro. I'm the Chief Administrative Officer at the Planning Department. So we were contacted by the complainant back in 2011 relative to Park Merced. We provided all the documents that were requested at that point. I have the file here. One of the complaints was it took too long for us to respond, but the size of the project, and we were unclear about the request, so we asked the complainant to either give us a phone or an email so we could communicate with the person. They refused to do that, so they communicated to us only through U.S. Post Office, and so it took us 3 weeks to sort of clarify what the respondent wanted. We then got a list of 3,470 pages on. And then we asked the respondent that they had to pay 10 cents a page, and we wanted $340. And then we went through several months of letters back and forth about how the complainant was disabled. And we said, well, you have to show proof of financial, and then we'll waive the fee, because we don't waive the fees unless you actually. So we went through this back and forth of the discussion. Last year, finally, after this had come to the commission or the task force several times, we finally just put all of the files, including the 3,470 pages, on the disk and handed it to the complainant in this room. And so we've, I just want to say the Planning Department receives public records requests every day. We have a system in place for this. We get thousands of these requests every year, and we know how to do this. We do it every day. We tried to meet the requirements of the complaint, and the biggest issue was not wanting to pay the $340, but the complainant also refused to fill out the paperwork showing financial hardship, so we went back and forth about that, and then we finally just said, okay, here's the files on a disk, because we want to also be done with it. But nonetheless, we feel like we've given the complainant all of the files related to Park Merced that we have, and we're not sure what it is that's not been provided to her.
Thank you.
Thanks.
Is there any facts and evidence In support of the respondent? Sure. I'd like to go to, because this case had been to compliance, and Member Washburn is the chair of that committee. I'd like her to refresh or to give you guys an idea of what happened in that meeting when we heard that case.
Right, so in attendance at the meeting was myself, Member Nee, and Chair Grant. And at that time, we heard from the complainant and also from the respondent. The reason we voted to return this matter to the task force is that based on what we heard that day, we were not satisfied that, first of all, the respondent had indeed received everything that she had requested. Certainly there were many delays, and you have many documents outlining all the delays and all the problems. We felt that her request was, she first requested a subset of all the documents, became very frustrated when that wasn't happening and she wasn't getting the specific document she wanted, so she ended up requesting everything. And we felt that the planning department did not respond in a timely way, did not work with her to make sure that she had everything she requested. And for that reason, we voted to send it back to the task force. It's still not clear in our mind that she did indeed receive everything that she asked for. As for the matter of payment for the documents, this task force has nothing to say about whether fees can be waived or not. We do say that paper copies are that departments can charge 10 cents a page, but so that matter is off of our table. But the issue was timeliness of response, and that was found to be a violation in the first place. I mean, that still was a problem. We feel that this request was mishandled all along the way. And, it could be one of those unfortunate cases where a department that tends to have a good system in place and things work out well, didn't work out well in this case that we could see. So that's why it's back here. Chair Grant, is that pretty much how you remember?
I remember that, and two other points that I just wanted to bring up, if we remember, was that the planning, which kind of is where I'm a little bit torn right now, is that we did ask Anonymous if she would work with the planning department because they were open, because they didn't understand what documents she was still lacking, if she would work with them. If the planning department said they would be more than willing to sit down, and she said that was not amenable to her. So she did not want to work with them to get those documents now. So that, kind of was something I think is important to note. And I think that's pretty much what I recall. I remember the other representative being at the meeting and saying that she wasn't sure about what exact documents the complainant wanted. Do you remember that?
Right, except the thing was, if there was some unclarity initially, and because of the way the planning department interacted with the with the complainant, she got frustrated and just asked for everything. And when you ask for everything, you're entitled to everything, and then the department has to provide documents on a rolling basis until everything is provided.
Okay.
So that's one way to work around, getting what you want is to ask for everything, and that's done sometimes. And, this was a discrete project that had, voluminous amounts of information. But there is a procedure, it's in the ordinance, for what to do in these cases. The department asks for an extension, they start providing documents on a rolling basis, and that just didn't happen. So that's why it's back here. And the respondent has been frustrated, yeah, you're accurate in that she
wasn't aware of what documentation. And if you could come here, Ms. Anonymous, just to clarify what documents she still wanted, if I recall correctly. When we were saying what documents do you still need, because the planning committee thinks they've given you everything, and just want to be clear about what what documents do you still want? What do you need?
Well, I'm not able to answer that because I was never given all of the documents, so I am clueless as to what it's actually. I do know some things were missing in regards to the $50,000 Park Merced gave District 4 for a project out there, which began to make me ask for everything. But what I would like for this task force to know, what happened was, it was a really nice thing that planning did. They delivered, I didn't ask them to deliver, but they delivered some things, primarily the EIR, those really big books, and they delivered an incomplete development agreement. And one of the things that triggered all of this were the 14 pages of revisions that occurred on May 24th. And I began to, the people partner said, we nicknamed them the 14 phantom pages, because that was very important for me to have, because I needed to know what had changed in the document. And from the very beginning, this came out at the hearing, they would not even mail me the 14 pages for 10 cents a piece, which would have been $1.40. I never said I didn't have $1.40. So without the revisions, there was no way I could ever know how this document was changed in the final hours before the full board voted on it. So from that point, I began to ask for everything, and I never got it, including the 14 phantom pages. And I would like to say that my son, who is here, is one of the persons who went with the neighbor and asked for these documents. They did not give them to him, and Mr. Hartz got the documents on 2 CDs for 50 cents each, which is $1, which is a lot less than $340. So I think that I cannot prove it, but I think that Park Merced has exerted tremendous effort over City Hall, and they were just told not to give me anything. And because I began this journey, I think it is one of the reasons that I lost my home. So no, at this particular point, I don't think they would give me all the documents anyway.
Complainant, can I ask a question?
Yes.
Yeah.
So I just want to make clear, because when we look at whether to, well, I'm sorry, let me be clear. When I look at determining whether something should be referred to ethics, I look at, was there any extenuating circumstances that led to the bad act or led to bad action by this individual? For example, was there a mistake, or was this done on purpose? Did they purposely try to prevent you from having the documents or from getting the documents? Was there reasoning that was in your belief nefarious or evil or just wrong?
Well, I think it's just, well, first of all, at the time I was a resident there. So I had the right to know, as the Brown Act was violated. These changes were made. The agenda was already posted. So on May 24th, the public had a set of documents that were no longer in existence because revisions had been made. Not everyone got a copy of the revisions at the meeting. And it's in the file if you were to go back and listen to this case. And if I remember correctly, Commissioner Washburn brought it to their attention. Why didn't you just mail her the 14 pages that she was asking for, and on a rolling basis mail other documents that she was requesting? So they never even did that. So for them not to have given me 14 pages, I don't think they have a leg to stand on. I really don't. There's no reason for that. I have gone down there They sent me to the controller's office. They told me the controller's office set the fee. The controller's office read the letter, and she said, no, this is a sunshine thing, and they need to just give you those documents. And there are certain people who are always before sunshine because other department heads do not behave this way. And you have one department head, I'm not going to mention them now, but they did the right thing. They're probably in trouble, but they did the right thing and gave me some documents, because the law, sunshine really is the law. People don't understand that. And they gave me all of the documents that I had requested in hard copy, and that was about 150 pages that came in the mail one day. You know, so it can be done. And when they, like I said, when they didn't give me the 14 pages to tell me what was taken out of the development agreement, what was put in, then the development agreement that they had delivered and spent the money for and put at my front door was no good, because it was a different document than what the mayor had signed.
Will the respondent please come up? I'd love to hear your response to why she didn't get the 14 pages, if you believe you had given her the 14 pages.
Actually, it's in the file. She received the 14 pages. The planner sent her the 14 pages. So I don't know why she's saying she didn't get them. Relative to the disc, I'd like to clarify that we initially, when she said she didn't want to pay the $340, we offered to give them to her electronically, and her response to the department was that she did not have email or computer access. That was why we never gave them to her electronically. She refused to accept the files from us electronically. She wanted them in paper. We said, we need you to pay $340, and we went around and around again. The length of the communication is because this was all done through written letters in the post office, because she would not give us a phone number or an email address like most people do, and so it just took weeks and weeks to have this conversation through written letters with each other. So again, the department feels like we've given her all the files. At a meeting last year in this room, we finally just handed her a CD. I'm not sure if she has access to a computer or not. I noticed that the complaint she filed has a Hotmail address on it, although she told us she doesn't have an email address, so I'm not sure what the situation is. All I can say is that the department's tried to comply with her request. We've handed her the documents. We've now given her a CD last year with all of the 3,470 pages on it at no charge, but we would not produce the hard copies of those because of the cost to the department. So, and she was given the 14 pages. It's in that file. The planner gave her the 14 pages she requested. She also indicated there were some missing letters from Assemblymember Tom Amiano, and those were also given to her, and they're in the file. So we think we've given her everything she's asked for. So,
okay.
Excuse me. So you say those documents are in the file, but you just brought the file today. So this is the first time you're giving them to her now.
No. This is a copy of what we gave her. This is a copy. I'm handing you a copy of what we've previously given her,
And when
including
was that file
the CD.
given to her?
It was given to her over a period of time.
Okay,
There's
so this is
letters
that.
in them also, starting back in 2011. So
My question is, when she asked for it, obviously time was of the essence, it seems, for her determination of, I guess, the project or the legislation that was being determined at the time. So what was the Planning Department reasoning for the delay in the 14 pages it sounds like she initially asked for, as well as the subsequent delays in getting her the information?
we don't think there was a delay in getting her information. I mean, the big stopping, what happened was she put in a records request for a number of documents, which we provided to her, and then she came in and wanted all 3,470 pages, which is when we said you have to pay $340, and then we went through months of these letters back and forth, how she refused to fill out the financial hardship paperwork, and then we ended up coming to the meetings here and we handed her a disc. So, and the fact that we were trying to clarify what specifically what she wanted, and that was done through written letters to each other. I mean, it took us 3 weeks to respond to her instead of the 24 hours or the 10 days, but again, we're trying to seek clarification through written letters via U.S. Post Office. And
So you don't know of any nefarious or otherwise reasoning why they would delay?
No. I mean, the idea that we somehow withheld documents on purpose, as I indicated, we get tons of requests on projects in the city every day, and we provide the public record. The planning department has no desire to withhold records from anybody on a project. It's our standard practice to give people records they request on. This is something, it's not unusual to us. We get these requests every day. People file requests on all the development projects that go on the city. It's just not, the department doesn't have a practice of withholding purposefully documents from people. So
I have a quick question, Mr. Planning. I didn't catch your name, but that's okay. So I'm looking at this list here, and it's 3,470. I'm sorry to be so pedantic. I'm stuck on this 14 pages. So with the 14 pages, would it be 3,484?
no,
total?
the 14 pages were not part of that request. So what's in those folders, she made a request to us for some documents. No, the hard copies that are in the manila folders. She made a request to us for some documents, which we provided to her. Then she came back and gave us that list that was 3,470 pages. At that point, we said, you need to pay 10 cents a page, so you have to pay $340. Those other hard copy documents that are in the file were given to her just free of charge, because we made a copy here and a copy there on a rolling basis, as you indicated, when we got those requests. So it was when she came in and said, I want all 3,400 pages, we said, you need to pay 10 cents a page.
Because she said that this disc was not sufficient?
Well, no, the disc was given actually after we went through this whole process, and she filed a complaint to the Sunshine Ordinance Task Force, and we came here, we brought a disc with us to a meeting and said, here's all the files, is this going to satisfy you? Because we'd gone back and forth about the $340.
Okay.
So we came to this task force, and we actually brought a CD with all the files on it and just handed it to her and said, can we just, here it is, can we just be done with it?
Got it.
So.
I just had a very clarifying question. The so-called 14 phantom pages. Do we have a hard copy?
Correct.
We do it.
Correct.
And she does too.
I can show them to you if you want me to.
No, it's fine. And
Yeah.
the complainant has a hard copy
Correct.
of those 14 pages.
Yes, those hard copy pages are in there. Is what was given to her hard copy.
And when was that given to her?
That was starting back from the original request in July. Those were handed over to her over a course of time when she came back and said, well, I want this and I want this. So that was done over a successive period of time because we got numerous requests, I think, starting back in July of 2011.
So just to be perfectly clear, you're saying that the complainant received hard copy
Correct.
of the 14 I apologize. I'm just referring to the so-called 14 phantom pages.
Correct.
Okay. I'd like to. Could the complainant come out to the microphone? I'd like to ask a question.
Thank you.
Thank you. Yes. Thank you.
Thank you, Mr. Planning.
Yes. So I'm guessing you can guess what question I'm going to ask. Have you received a hard copy of the 14 phantom pages that you referred to earlier in your
No, I have not. The last thing that I received from the planning department, which should have been with the other things, was the letter that told me when Park Merced submitted an application for their project to be considered. That was the last thing. I never did get the 14 phantom pages, and that did come out at the hearing of 11/068. I never did get them, and nor did I get the disc from the hearing. So that is the correct answer.
Thank you.
I have one more for you. You mentioned previously in your testimony that Mr. Hartz or another individual who comes to the Sunshine Ordinance Task Force often did receive the 14 pages? Or
Mr. Hart's, because I was tutored in Sunshine by Mr. Hart's, he was able to get all of the documents on a CD, and the CDs were 50 cents each for him. I was not given that opportunity, but I have ran into some interesting things in regards to, I've met resistance for some of these documents, and this project is very expensive. The city wants it to go through. A lot of money's on the line here. And I think that just given the fact that the very next day after the very first hearing, 11-048, that a 3-day notice was put on my door, they meant for me not to have those documents because they wrongfully evicted me. So a lot of things occurred in my attempt to get these documents, and they were very crucial because one of the problems for the tenants of Park Merced was no one had a lot of the documents, and we had thought that there were historic elements to Park Merced, which is true, and there will be something about that later on this month in one of the museums in the Bay. But that was why we wanted all of the documents to find out if there was something historic about Park Merced. So in addition to the changes made on May 24th, we just wanted to know the history of the place where we were living, and I was denied due process, and I never did get the 14 pages from planning.
So you don't have in your possession a disc? I'm trying to remember.
No, Madam Chair, because that was a long night. There were 3 consecutive hearings. And then that third one, the last hearing, the gentleman, he had a disc with him, but and it took to actually come. It took the hearing for this disc to even surface, and they never gave me the documents. And some things everything's in writing, so that it's absolutely clear what I'm asking. There is no hearsay. There's no phone call or I said this and you said that and you didn't say. So everything is in writing. That's why that's there. And when they didn't give me the 14 pages, I began to wonder, well, what is it that they're hiding from me? What is it that they're really hiding from me? And all of this was new to me, if you can imagine that, as it's still new for some of you, in just trying to get these documents and trying to organize people where I had lived. And we're trying to save our homes. We're trying to save our homes, and that's all we wanted. And that's why we called them the Phantom 14 pages, because we didn't get them, and they did run out at the meeting before the Board of Supervisors. Everybody did not get a copy of the 14 pages. So it was very, very interesting. And the document had changed several times, maybe 6 or 7 times before that day. So we needed that document to see what was taken away, what was put in, because we didn't know. We were absolutely left in the dark. I was one of the people left in the dark. I didn't have the changes.
Okay, great. Any more questions? Any thoughts on this?
Chair Grant, I had a question. There's obviously a lot of issues revolving around this case, and I think we have to separate the whole Park Merced story and really look at the nitty-gritty of what was requested, how timely was the response, was policy, was the sunshine policy followed here or not. However, I would like to ask some of the older members of the task force just about the Planning Commission in general. How good has their process been for adhering to sunshine requests? Can you recollect anything else from the past, especially Member Washburn, of past cases? And how would you rate their process based on your experience on this committee?
I guess I'm the most senior person here today. I don't recall. I recall another case or so from them, and I don't recall the outcomes. I would have to. I saw Doug Comstock leave the room. He might have a better idea about this than I do, or DCA Threet. But I don't know that that's exactly germane to the question. It might help us determine what to do next. We've had cases against certain commissions or departments over and over and over, and then you just sense that ethics is the place to go in this case. Other times it's you see that some systems are not in place, so education, outreach, and training would be a better place. And you're right, this case there's some definite sunshine issues here, but there's an overlay of a very controversial public project and the whole way that went down that's involved here too. So,
But we need to remember that we are here to see if she received the documentation that she requested. And I mean, that's where our jurisdiction, understanding the history, remember Chair Washburn from meeting, but I really try to focus in on that, and I hope we remember that because it's important in what we can and can't accomplish in moving things forward to Ethics Commission and moving things forward back to compliance and amendments to whichever education outreach. I think it's really important to remember it's about the public records and what she received. She's saying she didn't receive it. The Planning Commission is saying that they have given it to her, and I do believe there was a lot of issues. That's why it went to compliance amendments the first time around, and that's why we're getting it again. And so we're right now saying she still hasn't received, and correct me if I'm wrong, she still hasn't received the documentation where the Planning Commission Planning Department is saying they did give her everything. So that is my conundrum as far as the documentation. So that's kind of where we are.
Well, I wanted to say that, DCA 3, did you?
Through the chair, not to speak to the question of the planning department's history, but rather to the what's before the task force. This is an order of determination that was issued in the past. The violations themselves have already been adjudicated and found in the order itself. So the focus of the task force in a referral for enforcement, rather than considering whether those violations happened and those matters that were originally considered, the focus is on whether the order has been complied with. And this order has, there are challenges in these orders for the task force, and I think this order is instructive in a lot of ways because the less specificity there is in the order about what the task force is finding as a violation and exactly what they want the department to do, the harder it is when it comes back on an enforcement referral to know whether the task force complied with that order. Mm-hmm. So,
whether the department complied with that.
Yes, I'm sorry, whether the department complied with that order. So the decision itself in this order is to provide Anonymous with copies of all Merced project documents that have not been provided, and to do so in a mutually acceptable format within 5 business days of the order. It appears from the record, if you look at the letters that are here, like for instance, page 45, the Planning Department in 2011 offered the CD at that point to complainant. I don't know what kind of follow-up there was from either party after that letter went out, but it appears from the correspondence that the complainant preferred to have them in a physical form and insisted that that happen through a waiver of the fees, claiming requesting an accommodation under the ADA to obtain that waiver. And, I don't personally recall what happened at the hearing as to whether a disc was offered and rejected or offered and are not offered. I don't have a recollection of that, but you have before you the different parties' versions of those events, and you have the order before you.
Thank you. Member Washburn?
I was just looking at the order of determination again, and so also, some of the key terms are mutually acceptable format, so that was kind of the sticking point here. As far as the timeliness, probably not, all this didn't happen in what we would have regarded as a timely matter, but so I think the important documents in this case were 14 pieces of paper, and there was no mystery as to what they were for, and why they were important. And so I think that the respondent appeared to want the hard copies of those pages and was frustrated in her attempts to get them. And I believe that's where this is all falling apart. I mean, there were problems all along the way, but she wanted specifically those 14 pages. It seems to me that would have been easy to comply with, hard copies of those. Might have satisfied. If the complainant, please, could. I know this has taken a very long time, and it's hard to remember everything. So am I characterizing this correctly, that you were primarily interested in those 14 pages, that you hadn't received a copy at the meeting? There weren't enough copies to go around. And so you asked the planning department for those, and you didn't get those from the planning department when you initially asked for them. And so you were frustrated and said, well, just send me everything.
That would be correct, Commissioner Washburn. Looking at the document, I realized that to look at the video, it was saying one thing, and I didn't have what it said. And then that's when I had asked Mr. Cooper. I had thanked him for sending the development agreement, and I had asked him for the 14 pages of revisions. And then I think the next time he responds to me is 3 weeks later. But, excuse me, but he never did send the 14 pages. They never did come at all. So that's from that point going forward, I began to use all of the documents, so that I would be absolutely clear. And as I said, that's why everything is in writing, so it's not hearsay. But no, I never did get the 14 phantom pages, as we call them, from planning. And that's what begins all of this.
Okay, thank you.
Mm-hmm.
I guess the next thing is there going to be a motion on what to do, what the task force would like to do next regarding this case. If you want to refer it to education, do you want to ethics, back to compliance amendments?
I think this case it's incredibly confusing. I agree. It revolves around these 14 pages. And one side saying they haven't received it, and one side says they gave it. And so short of, swearing on a Bible and attaching a lie detector to somebody, right? I mean,
Member Washburn?
I'm thinking that the best way to handle this is for this to go to education, outreach, and training. And the reason I say that, I think knowing ethics, I think this would be a hard case for them to deal with. It's hard for us to think about. But one thing we can be clear about is that the system didn't work here. It seems to me that, and here's a member of the public who did not want to use email, did not want to use phone calls, wanted to have everything in writing and use the mail for whatever reason, and that's anybody's right. And I think departments have to develop procedures and systems so that they can work with the public to accommodate what the public needs and wants in a reasonable way. I think that this is an opportunity for one of our committees to help think through these issues so that this type of thing doesn't happen again. Here's a case where I think the original request was pretty straightforward. These are 14 pages that have become sort of famous in this building. And so what she was asking for was not mysterious at all. And so here's a request I think that could have been fulfilled quickly and wasn't and I don't know the reason. It could have been because planning wanted to hide something from members or from residents of Park Merced. I don't know. I don't know what the truth is here. So, but I do know that the system didn't work, and somebody became very frustrated and has had to go to many lengths to get what she wanted. But importantly, she's brought a problem to light. That departments, have to meet the challenges of responding to public records requests and work with people. And so it could be the department has some good systems. We don't know. They could tell us about it. And education, outreach, and training. That's a place to start.
So would you like?
So I would like to make a motion that we send this to education, outreach, and training.
Before she makes that motion, could I ask, could we do a two-part approach? Can we still not have this issue go to public, go to outreach and education in the sense of working with, the members of the public to help them understand, especially when they have to fill out forms of disability or financial hardship, and how important that would have been in this process to speeding things along, but at the same time also elevate this to the Ethics Commission for that violation.
That would be two separate motions. And so she has a motion on the floor. Is there a second to Member Washburn's motion?
I'll second.
It's been moved and seconded that we send file number 11068 to Education, Outreach, and Training. It's been moved and seconded. I'd like to open that up to public comment. If there, DC3.
Through the chair, as a procedural matter, if Member Highland would like to amend that motion, the time to do that would probably be now rather than after public comment, so that you have a motion before the public and they know what they're commenting on. But that's just a suggestion. It's not required.
Okay.
Through the chair to DCA Threet, can I add something in addition to what she proposed, or is there only one action that can be taken on this file?
A motion can include any number of actions by the task force. If you would like to make a motion and the original maker of the original motion accepts it as a friendly amendment, and the second accepts it, then then you don't have to move to amend it. But if they will not accept it as a friendly amendment, then you have to make a motion to either substitute or amend the original motion with your own motion.
Thank you. Well, then I'd like to propose a friendly amendment.
Could you repeat what you're adding?
That in addition to sending it to Education Outreach, we also do refer this to the Ethics Commission for that 14-page document that was not treated in a timely manner. I think we still need to.
Can I say one thing? I think that what Member Washburn was suggesting, the reason to send to Education Outreach is because it's going to go to ethics. I don't know exactly what your wording was, that this issue was not going to really be addressed in the matter that is that what you were saying? To be clear, that's why it was going to Education, Outreach, and Training, which I agree. I'm going to tell you, I will support Member Washburn's. I'm not going to support this going to ethics at this time, but just to understand
But it's
why-
possible that after going to education outreach, it could then go
Yes.
to ethics. I understand. All right.
Yes, right? It can come back to us after education, outreach, and training, and then we could then decide it can go to ethics.
Okay, that might clear it up a little bit and make it a better case for ethics, so I agree with that. Okay.
After they've gone to education, outreach, and we've given an
Yeah, so I
opportunity.
withdraw that friendly amendment.
Okay.
Okay. So at this time, I'd like to ask for public comment on this issue, on this motion on the floor. I can't see. There's no public comment? Then, okay. Can you stand to the mic?
Sure, I'm Debbie Brubaker, and here on an entirely different matter, but just in listening to all this, I would like to know if the Planning Commission or committee where they're trying to get the information, if they've ever heard of certified mail, where someone has to sign for something when they get it.
Thank you. There's no more public comment. Madam Clerk, can you take a roll call vote?
Member Monet?
Aye.
Monet, aye. Washburn?
Aye.
Washburn, aye. Sims?
Aye.
Sims, aye. David?
Aye.
David, aye. Highland?
Aye.
Highland, aye. Oka?
Aye.
Oka, aye. Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
You have 8 ayes.
Motion's passed. This matter will go to Education, Outreach, and Training, at which time, I'm sorry, sir, at which time we'll move forward from that. Yes, sir, public comment. Yeah, I'm going to do public comment. So ready. I'm going to, item 5, general public comment.
Item number 5, public comment.
Yeah. Can I get a show of hands how many people are going to offer public comment? For that purpose, can I give you 2 minutes, please, for this evening?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. Despite the fact that this task force has been meeting for a number of months, the last order of determination issued was in May of 2012. The importance of holding hearings has been cited as justification for a number of questionable changes, such as cutting public comment to 2 minutes, scheduling complaints for hearings in no discernible order, and other changes. It is a fact, however, that everything else becomes meaningless for complainants if they cannot get an order of determination, or a referral based on the complaint. And as far as I know, no referrals have been made to anybody. I had one case found in my favor in November, another in December, and here I am in February waiting for anything as a response. And as far as I can tell, nobody has gotten any referrals sent to the proper bodies or any determinations. And we're coming up on a year since that last one was issued. I've contacted the chair through the administrator on several occasions regarding this matter and have only had vague commitments, the last one being that they would be available by the end of January, which they were not. I have 2 outstanding referrals, one of which is based on a complaint originally filed in July of 2011, with which I cannot move forward, lacking the necessary documentation. The Library Commission simply refuses to do anything in response without getting the orders of determination. This situation is totally unacceptable and must be corrected immediately. And as I mentioned earlier, the idea that last meeting only 7 members showed up goes to the pattern we had before, which is people having to have 6 out of 7 votes to win, and that puts an unconscionable burden. I also feel that the proof is always put on the complainant to prove the documents were withheld. And that's not the way this law is supposed to work. It's supposed to be the respondent who proves they complied, not the other way around.
Excuse me, William Clark, members. I have 2 things. One, I just want to make you aware, and Ray, aware that one of your cases, which you referred to the Ethics Commission, is going to be heard by the Ethics Commission this month on the 25th, and I invite anybody to attend that. The second thing is I just wanted to make you aware that if you recall, the previous Sunshine Task Force was removed from office as a result of the bylaw change that the city attorney ruled was a violation of the city charter. In my own investigations, I became aware of an ordinance that was written by the Board of Supervisors regarding the suspension revocation procedure of a street artist certificate. And in that ordinance, the city attorney wrote that only 3 members of the Arts Commission was necessary. Was going to be allowed to vote in favor to suspend or remove a street art certificate. And I recently filed for a hearing in front of the Arts Commission to amend that ordinance on the very same basis that the city attorney ruled in your own case. So I want to make you aware that this is pending, and that this has been about a month and a half ago that I pointed out to the city attorney and the Board of Supervisors that this ordinance violates the same ordinance you guys were in violation of. And I recently received a response from Mr. Lazar, because it's been a month and a half, and he decided this for you so quickly. And I got a response back from Mr. Lazar that the city attorney is still working on it. So I just want to make you aware of that. This has taken 2 months for the city attorney to make this decision, which he already made in your case. And as soon as some more information comes my way, I'll pass it on to you.
Thank you.
The better half of the set, Robert Clark. To follow up that slightly, I want to make it clear that in this ordinance that we discovered that the Board of Supervisors passed, there's actual language in the ordinance that says that a street artist cannot appeal the decision of the majority of the committee to the full Art Commission. Now, I mean, this is an actual ordinance passed by the Board of Supervisors. And yet the Board of Supervisors tore apart this task force for violating the same city charter. And, we intend to follow up on it, but I do want to make it clear that this is explicit in the ordinance that they actually say that a street artist cannot appeal it to the full Art Commission, when the city charter that they use to remove these task force members says that every action by every board and commission must get the majority vote of the full commission. So I just want to say this to the city attorney and the Board of Supervisors, that calling the kettle black can, kind of come back and bite you on the butt sometimes.
Thank you. Is there any more public comment?
I think I've spoken in the past about problems with the San Francisco Arts Commission, their tactics of delaying, not responding, not giving over documents, and just generally no communication whatsoever. I think it's very difficult to function under those kind of circumstances, and it's very stressful. So even though I lost the previous complaint, I did refile, and eventually I'll learn your rules, and I'll learn how to speak in public. And my apologies to you.
Thank you.
I'd like to make a public comment about the case of Anonymous versus Debbie Brubaker. I have worked with Debbie Brubaker many times over the past years, and I would just like to state that I've never once seen her make a list of people who should and should not be working. And not only have I never seen her make a list, I have never seen her pass so-called list on to other producers and studios. And I'd also like to mention that as far as I know, the Sunshine Committee should have all of the documents that Anonymous has requested. Thank you.
Thank you. Is there any more public comment?
I would just like to say that I hope going forward that the task force commissioners are aware that in some instances, some of the complainants may not be as well polished or as well dressed as some of the respondents are, some of whom are department heads or elected officials. And you're going to have to decide who is telling the truth. And it's going to boil down to who has the facts and what kinds of facts there are. And I think, in my particular case, I think people are realizing that this is a very serious issue given what has happened and what has transpired. But it's very, very interesting to see how many people who are in violation of the Sunshine Ordinance because they haven't even gone through their training. It's just unbelievable how some of these people with the salaries that they make do not even go through their training. And I'll just leave it at there. And then they want to come here and pretend like they've never heard of Sunshine, or, since I've talked to you, I'm going to go brush up on my skill set, but it doesn't work that way. They have to go through training every year. Thank you.
Thank you.
Hello, I'd like to address file number 12034, anonymous against Debbie Brubaker. My name is Claudine Huey, and I'm with the Directors Guild. I'm a member of the Guild and have been for quite some time, since the mid-'80s. I've known Debbie Brubaker. She is the chairperson of the Directors Guild here in San Francisco. She has always been above board. She has never played favoritism to anyone. If anything, she has always been very fair. So I do want that to go on record with regard to Cliff Roseman's accusations that, she may have taken jobs, this and that. I understand that the Film Commission has provided all emails that Cliff Roseman has asked for. So at this time, in his absence, he should be able to take a look at those emails and see if he still has an issue. Thank you.
Thank you. Is there any more public comment? If not, then I would like to, if it's okay, move on to the next case, and then we'll take a break after that. Madam Clerk?
Yes. It'll be file number 12040, complaint filed by anonymous against...
38, I believe, right? 12038.
She withdrew, I'm sorry. Okay. File number 12038, complaint filed by William Clark against Ben Rosenfeld, Controller, for allegedly not providing legal authority supporting that the Arts Commission can legally exceed amount budgeted to street artist program and spend the surplus without approved supplemental appropriation ordinance.
What does he have?
Oh, hi. Let me deal with the jurisdiction first. And there is no, the controller did not contest jurisdiction, so it's accepted by both parties. I need a motion and a second to accept this jurisdiction.
So move.
Second.
Did someone second?
I'll second that.
Thank you. Been moved and second and passed without objection. Mr. Clark?
Yes, I'm William J. Clark again. Just to make you aware of what this really is all about, was back in July 2011, the controller came out with his audit of the street artist program. And in that audit, the controller ruled that the management and supervision charge, which was charged the street artists in the 0910 ballot, was, in the 0910 budget, was improper, and that the procedure that was used was improper because there's no public hearings, there was no nothing, and that as a result of that, I went through with the process and got that $18,000 returned back to the street arts program. Well, in the process of doing the 2011-12 budget, I was given a document which included the actual budget for FY 10-11, which was the very next year. And in that budget, there was a charge of $19,953 for a management and supervision charge. I asked the controller how that was possible, and I got information back to him that one of his assistant deputies signed a warrant a month after the auditors the controller's audit came out telling the Art Commission that they couldn't do that, that was improper. And I questioned, I put a bunch of emails in here, but I went through the process with Leo Levison trying to ask him, well, how is it possible that a month after you told the Arts Commission that this was improper because the method that was used was improper, and then the next month you signed off using the very same method another additional $20,000. Well, through a process of emails, we went back and forth, and he said to me that, I sent him the charter, administrative codes, all saying that as a result of this cost, the Art Commission actually went over its budget that was approved by the Board of Supervisors, and I sent him ordinances and authorities all saying that was improper and illegal, and that if they were going to go over budget or if they were going to ask for another expense, that they should get a supplemental appropriation from the Board of Supervisors to a supplemental appropriation ordinance. And I questioned what had happened is he refused to answer my questions further and sent me to Mrs. Amuda, and she refused to answer the questions at that point. And so I asked the controller to provide me with the legal authorities to support their premise that they could take money to pay for an expense which wasn't in the budget, was never approved by the budget, and actually as a result of that went over budget. And that's the legal authorities that I haven't received. So I'm just saying that I would like you to order the controller to provide me with the legal authorities to support their position that what they claim they can do, they can actually do. And it's kind of confusing as usual, but if you have some questions, that's what this particular case involves.
Is there anyone with any facts and evidence in support of the complainant?
I'll say something to try to clarify it a little bit too. So, we find out that this second $19,953 was charged to the Street Arts program. Now, in the controller's audit, the Art Commission answered the controller's audit by saying, well, look, we're not going to charge any further management and supervision until the 2012 year. In the amount of time between them, we're going to do an hour analysis of the actual hours used by the management to supervise the program. And yet, after they write to the controller and say they're not going to do it the next year, a month later, they charged us the $19,953. At a committee meeting, I asked Miss Beltran, who was the president at the time, how they could do this, and she said, "Well, we have a new system now, which we're doing it. Actually, we're doing it by a head count now. Now we're going to determine how much management and supervision charge we're going to give you by your Street Arts program has 2 employees, and we have 30 employees in the Art Commission. Therefore, now we're going to arbitrarily say we are supervising you 7.5% of the time." And at the same time, the director of the Street Arts program had just presented a 6-month time study which showed that only 11 hours of managerial time was spent supervising the program, which meant an average of 22 hours a year, which was a lot less than $18,000. And so they claimed, the Art Commission claimed, that the controller okayed this new concept and that they were going to back charge us under this new system. And that's why Bill and I started asking the controller for legal authorization, because the law clearly states, and we presented the controller with all the legal authorities that show that what they did was illegal, is illegal, and we basically asked them, show us your legal authorities, and they never showed us the legal authorities. And that's why I was hoping they'd be here tonight so they could show us the legal authorities that they claim that they can do these illegal acts, but they're not here, and we're asking for you to, make an order of determination that this is a willful refusal by the controller to provide this information to us.
So the representative from the controller's office is not here tonight? Okay.
Do we know why nobody from the controller's office is here?
Let me ask, Madam Clerk? Oh, I'm sorry. Yes, I can see. Did you ever hear any response from the controller's office?
No, a response was not given towards this case, particular case 12038. No.
So you didn't hear any?
And just so I'm clear, I don't see any response at all.
Madam Chair, I recall an email from Monique Zamuda. I don't know whether it was covering both of these or one of them, whether she was going to represent the department for one or the other or both, but it requested that these matters be put off until after, I believe, 5:30, because she had a doctor's appointment or something like that that she had to go to, and then she would be here after that.
After 5:30?
Yeah.
Okay.
But I did not have any written responses on these either.
Okay, so.
Well, just point of order, so we have it for the record, is 5:47.
5:45, right? 5:47.
Yep. I have a question for Deputy City Attorney Threet. Is the city attorney the attorney for the controller's office also?
Through the chair to Member David, the city attorney is generally the counsel for all departments in the city. There are a few exceptions where the department has also hired someone under a different classification to provide legal advice, but the official counsel is the city attorney, and that's true for the controller as well.
So, I'm sorry, William. Sorry. So basically, I just want to make sure. So, what you're basically looking for is a legal opinion from the city attorney to the controller saying this is the authorization.
No, that's not quite accurate. What I'm asking for are the legal authorities, which the controller claims gives the controller the legal authority to sign a warrant, which for an expense that wasn't included in the annual appropriation budget. Two, as a result of that warrant being signed, that it put the budget over budget. The department went beyond the budget. So I'm actually looking for the laws, and because Mr. Levinson did say to me, well, ask the city attorney, and I responded to him that the city attorney doesn't allow for the public to ask him questions. He's the attorney for the city, and me asking him, he could just refuse, and that's why I asked the controller to provide me. I don't need the opinion. I mean, if he wants to do that, that's fine. But I want to see the actual laws that say that the controller has that a department can, that the controller can sign a warrant, which for an expense that wasn't included in the department's budget, which results in the budget which results with more money being expended than what the department was budgeted for. A little confusing, but a slight distinction.
I guess I'm a little bit confused as to, I just want to, it seems to me, and I hope that someone from the controller's office will walk in, that if they're requested something that it sounds to me like you're requesting, what is your legal argument for doing what you just did?
Basically.
Right, and so that they're going to turn to their attorney.
I would think so.
Right, so I guess, when I just asked you, are you looking for a letter from the city attorney on behalf of the controller that explains?
Well, I'm actually just asking for a response from the controller saying that the city attorney provided him with these legal authorities, and these are the legal authorities.
Fine, okay.
It doesn't have to be from the city attorney.
Right, I
Okay.
understand. Okay.
Yep.
So I guess the two things we can cite is that the respondent is not here to answer, so it's 5:50. And then,
And also, Madam Chair, if I can just say,
yeah,
it doesn't look like the respondent has put in any written response in to the complaint that has been made, or responded to the complainant after they filed your complaint, correct?
Right.
Well, I mean, I don't know if we need to. I mean, obviously, I think we should finish up the process. But as soon as we're done, I think we know what we need to do.
yeah. Are there any more comments from the task force? In that case, would Mr. Clark care to give some?
Yeah, I'll be brief. I just want to say that what I'm saying is that the controller sent me an email specifically saying that they do have the legal authority to do what I claim. They don't have the legal authority. And I sent a bunch of laws, city charter sections, administrative code sections, all which support my point of view. And so all I'm doing is asking of the controller is to provide me with the authorities that he claims support him. And as you see, they didn't respond.
The only response I see is from March 20th, when he tried to explain. That was the only thing. Okay, but he didn't explain the legal authorities. Okay. Is there a motion to find a violation of the Sunshine Ordinance? If so?
I guess I would make a motion to find a violation of the Sunshine Ordinance. I'm trying to figure out what section. Sorry.
Yeah.
67.21.
B.
And I don't know if I would, I guess 67.26, prefer you to keep withholding to a minimum. Yeah.
Okay. What is it? Which one?
I think 67.21 and 26.
2126. DC 3?
And Madam Chair, just in connection to the previous enforcement action where we were considering the order of determination, the more findings of fact that can be made to support determination, the better if it comes to enforcement of it later. So it would be useful to have findings of what facts constitute the violations in question.
And I guess added to that motion, we would, unless we have someone from the controller's office here right now.
Are you from the Controller's office? Okay. So, good timing. We were actually
Well,
just
I'm going to withdraw my motion until we can
hear from the respondent. We just
hear
heard,
her response.
yeah, from the complainant. He gave kind of a summation of everything I'm sure he's been talking to you about. On the first case, which is case number we are hearing right now, 12038, against the controller, Ben Rosenfeld. Do you want the clerk, Madam Clerk, to read it to you? So you know which one we're referring to? Can you read it again, Madam Clerk, just so she's clear which one we're talking about?
We're on item number 4, the complainant against Ben Rosenfeld, controller, for allegedly not providing legal authority supporting that the Arts Commission can legally exceed amount budgeted to street arts program and spend a surplus without an approved supplemental appropriation ordinance.
Thank you very much. My name is Monique Zamuda. I'm Deputy Controller, Deputy for Ben Rosenfeld. We in the Controller's Office staff have had numerous correspondence with Bill and Bob Clark regarding this particular matter over a matter of months. There is a complaint about the Arts Commission Street Artist Program spending fee revenue and the allocation of that revenue to operating expenses. The controller has opined on a number of occasions through a numerous correspondence that the revenue, the excess revenue that was identified at the end of the year was carried forward into the subsequent year to pay for operating expenses. We did confer with the city attorney. We make these kinds of financial judgments on a regular basis, and we notified Bill and Bob Clark of that. And they asked a number of additional questions. Again, we responded, and we really came to a point where there was no longer any request for information, for documentation. It was an argument, a disagreement, if you will, about the concept of this excess fee revenue and whether or not it could be used. So I, on a number of occasions, said this is the final Controller's Office opinion about this matter. And the emails continued. And therefore, I mean, there was no documentation that had been requested that wasn't provided. There was no interpretation or discussion about the matter that hadn't been provided. We felt that we have spent a huge amount of analytical time, not just providing information, but doing analysis for someone who's complaining about the way the program works. And not everybody agrees with the way the program works, but that is not a policy issue or whether or not the funds are appropriately expended. They were appropriately expended. We notified them as such, and so we have this disagreement.
I don't know if there's any facts or evidence, anyone else here for that, but I'd like to open it up for questions.
I guess, Madam Chair, if you let me, it seems like he has said, the complainant has said, that all he wanted to know, and in his papers and his complaint, he makes it clear, provide me the legal authority supporting Mr. Levinson's opinion. I'm asking you to provide me the legal authority supporting Mr. Levinson's opinions. And is it fair to say that by asking that, he is wanting the information provided to him, provided to Mr. Levinson by the city attorney regarding under what legal authority the City Arts Commission has the right to spend the street artists' funds in the way that he has complained about?
I believe we have responded numerous times to that question.
Okay, can you show me that?
On November 8th, and I will just read it, and then I will submit you part of this correspondence. On November 8th, this is after Mr. Levinson responded again and again and again, and finally I said, let me give it a try and see if we can respond to this so that at least the complainant understands the rationale. And I did say that, as we have reported to you in the past, as a general rule, departments may not spend special fund proceeds unless the Board of Supervisors appropriates these funds in the appropriation ordinance or through a supplemental appropriation. This is also the case for the Street Artist Program. See San Francisco Charter Section 9.101 and San Francisco Charter Section 9.103. San Francisco Administrative Code Section 10-100-32, Arts Commission Street Artist Fund, and San Francisco Administrative Code Section 10-100, Administration of Special Funds. Each of these citations provide the authority of the controller to allow for funds to be carried forward and authority for the creation of special funds and the circumstances under which those funds can be spent. So those are 4 legal citations that we provided. I further say, once the Board of Supervisors appropriates funds to the Arts Commission for the Street Artist Program, and absent legislation imposing a time limit for those expenses, the Arts Commission may, and I underline the word may, expend those funds for such authorized purposes as long as the funds remain available. So these dollars that come into the fund are continuous dollars. It's a continuous funds. It doesn't close out at the end of the year like many of the other cities' funds. And so long as the board appropriates authority to spend money in the subsequent year, the program is able legally to take those excess funds and spend them for program purposes in the next period. So they can't spend them for something else, but they must spend it for the Street Artist Program. Those costs were appropriated. They used the fees for that purpose. It's perfectly legal. It's common among special funds.
Not to interrupt you, but I just want to see the communication.
Of course.
Yeah.
So again, I'm just trying to give you context, and there's no further explanation that I can provide, no further citations I can provide. I work with the city attorney on a regular basis. We have, many more complicated issues that sometimes are either way. This is not one of those. This is a common approach. The program was fully authorized by the Board of Supervisors appropriation ordinance. The fees were collected in accordance to their fee schedule. It's an appropriate expense. They may not like it, but that's not something that we can help.
Member David? Oh, do you have a question?
I was going to ask Mr. Clark a question.
Okay, great.
Thank you.
I would like an opportunity. Yes. Yeah, I was going to give that to you now.
Go ahead. Sure.
And
Why
then
don't you
you
do
can,
that, and then if-
now that you've heard what the control.
Okay, thanks. First of all, she is totally mischaracterizing and lying to you about what I asked. I never asked whether or not the Street Artist Fund could carry over surplus funds from a previous year and use them the following year for legitimate expenses. Matter of fact, I've been arguing for years that that's the appropriate thing to do, and the city has been refusing to do that. What I asked for, and that's why we're having our argument, because she sent me an email saying exactly what she's saying to you now, which is I answered your question, which was this, and I sent her back. I said, that's not the question I'm asking. Of course they can do that. Like I said, I want them to do that. I'd be a fool to think that they couldn't carry surplus funds over from one fiscal year to the next fiscal year and use them. What I am asking is, and asking of them is to provide me with the legal authorities that they claim exist that gives the controller the authority to approve an expense which 1 month earlier he told the Arts Commission was improper and illegal to do through the method that they did. I asked him to show me the legal authorities which allow the Arts Commission and the controller to allow the Arts Commission to have an expense which wasn't included in the biannual ordinance appropriation ordinance. It was not there, and I asked them what laws allow them to go over budget in doing that. And as a matter of fact, I received that email which you have there on November 8th, which I believe she also says in there that it refers to case number 12039, so I was a little confused on it. But all those authorities that she cites are the legal authorities that I sent to Mr. Leavenworth and the controller. They're the exact same ordinance, city charters sections, and administrative code sections that I claim. This is all it says. And what I'm trying to say to you is she is misrepresenting to you my request, and I am very upset that they try to come in here and claim that I think that surplus funds, that I'm arguing with them that's about surplus funds being able to be carried over to the next fiscal year. That's absolutely absurd for them to claim that that's what I'm talking about. They know I'm not talking about that, and I feel that's a deliberate misrepresentation on the controller's part to confuse you and to confuse the public into thinking that I'm so stupid. I would think that the city couldn't do that.
Thank you. I'd like to offer you the opportunity to respond to that,
I have nothing more to say. I don't understand really the complaint here. The constant written communication was about whether or not these funds were authorized to be expended. They were.
Okay.
Sorry.
It's okay. Thank you. Member Sen.
Can I complain? So basically what you're saying is you still don't have an answer to your question.
No. And I have all I want to say is I have a misrepresentation of what I am asking for that makes it look like I know nothing about financial law, and I've been involved in this for 40 years. I found hundreds of thousands of dollars that were withheld from use from the Street Arts program, which has resulted in our fees being raised. And I just feel that this is such a blatant case. Even in my emails that I have in the folder, she makes that very same claim where she says, I've already answered your question, that you claim, or you're arguing it's going back and forth. And I wrote an email back to her, chastising her, saying, don't do this again, because that's not what my claim is. That's not what I'm talking about. So, I'm sorry for being emotional, but I really am upset that they would come in here at the last second and then trying to characterize what I'm asking in that manner.
Mr. Clark, on August, I'm looking at a document right here, and it says, I believe this is from you, a complaint sent Monica Zamuda of the Controller's Office, an email reply as follows. It says, the Controller's Office has not answered the last 3 questions I just asked you.
No, that's in the next case.
That's the
next case. No, that's okay. It's confusing.
We're in 120.
Sorry,
You got
I
it?
apologize.
That's okay.
I know.
Yeah. So I apologize to ask this question. I'm a little bit confused about can you put into layman terms simply the question that you want answered by the controller? Because you said I want the legal authority, and I feel like the controller came up and said, well, here's the legal authority, this section of the of the city charter, da-da-da-da. And you said, well, that's not the question I'm asking.
Right.
And so I just...
Right. The only legal authorities that the controller provided me with were legal authorities to a different question than what I was asking. The question that she claims that I'm asking, which is whether or not surplus funds in a special fund can be carried over and used the following year for legitimate expenses, they provided me with those legal authorities, which aren't the ones I asked for. Matter of fact, those are, like I said, those are the very same authorities I'm claiming state that they're forbidden from making any expenses that weren't included in the supplemental, in the biannual appropriation ordinance. Another little, but so I'm saying that I specifically asked for them to show me the legal authorities that allowed them to sign a warrant 1 month after they said the process was illegal for this management and management and supervision fee. I asked them to show me the legal authorities that allowed them to do that without first going in front of the Board of Supervisors and getting approval by the Board of Supervisors, which is provided in those charter and administrative code sections. And I asked also for the authority that would allow the Arts Commission and Controller to sign a warrant which put them over the budget, when every department head has to, at the beginning of the year, after the budget is approved, has to sign a document stating that they will not go over budget and that they will not spend any money on any expenses without first going in front of the Board of Supervisors. So I'm looking for those specific authorities. And, I got this letter in November something, and like I said, I don't recall, I forget exactly when I filed this complaint, but since then and now I haven't received anything else.
Jerry?
Through the chair, the members of the task force, if you look on page 213 and 214 of your packet, it's immediately after the city attorney memo. That's the actual written request. That's the basis of this complaint. So what we've been hearing from the parties is their characterizations of this request. The actual request is in writing and can be reviewed at those pages.
It's a problem for us, yeah. But it's right after the memo from. So it's page 9, 10 of.
Do you have the result complaint? Okay. Are there any more questions from the task force?
So Mr. Clark, so in this in the reading of this letter, it looks like Mr. Levinson responded to you on March 20th, 2012, that at the end of fiscal year 2008-2009, there was over $41,000 in available fund balance and appropriation authority left over.
Right.
This provided more than sufficient additional budget authority in fiscal year 2009-2010 to cover the additional $220 that was spent above the amount appropriated to the annual budget.
That was a typographical error on his part. They went 4,000 over the budget, not $220.
Okay, that's fine. But they're saying that there was $41,000 in the previous year's budget.
Surplus left over.
Surplus left over, and that can be moved forward, okay?
Right.
And
as a result of the management fee, which wasn't included in the budget, they went $4,000 over. They exceeded the budget by $4,000. That's what he's saying. And all I'm doing is asking for the legal authorities that allow him and the city and the Arts Commission and the Controller to make those to issue those warrants without first going to the Board of Supervisors and get a supplemental appropriation ordinance.
okay, so here's my question, though.
Okay.
So, do you agree that it sounded like you just made a comment just 2 minutes ago saying that you agree that previous year surpluses can be used and you want them
the following year.
Right. So if at the end of fiscal year 2000-2009 there was a $41,000 surplus.
That's at the end of 09. You're saying 09-10. There was a $41,000 surplus, yes.
At the end of 08-09?
Yes, I'm sorry, 08-09. That carried forward to 9-10.
Correct.
We held the budget, it was passed by the Board of Supervisors. It did not include the management and supervision fee. At the end of 9-10, a month after the audit came out from the controller, telling the Arts Commission that the same previous charge was improper for the very same reasons I'm saying now that were used the following year.
So you're saying the same can you give a little bit more specifics?
Okay, sure. In the audit explains that the year before this fee that I'm talking about, there was a management supervision fee that was charged the Street Arts program without there being public hearings, without it going in front of the Board of Supervisors, and without there being a method to determine the accuracy of that fee. And in the audit that was presented by the controller, he ruled that that process was improper. In other words, illegal. Okay, he told the Arts Commission that was an improper method, and they would have to come up with a new way of doing that. The Art Commission agreed, and they said they would not charge the Street Arts program a management and supervision charge until fiscal year 2012. And then when we were going over the budgets for 2012, that's when I found out that they charged us a month later. And that's when I approached the controller for the legal authorities to allow them to do these things. And that's where we're stuck at right now, is that I said that there are no... I've done my research. All my research says all this stuff has to go in front of the Board of Supervisors for a supplemental appropriation. If it's a mid-year expense, if any department thinks they're going to need more money in the middle of the year, they can't just go out and have the controller write out a check. The supervisors have to approve that in a supplemental appropriation. And also there has to be public hearings. There were no public hearings. I'm sorry.
Member Oka?
As I understand what Mr. Clark is saying, is that Mr. Levinson disapproved an appropriation, and then subsequently a warrant was approved.
The next year.
And where's the authority to do that, once the first thing was disapproved,
Right.
then you have to go again to the Board of Supervisors to get approval. And
Basically.
that was not done.
Right. Yeah, exactly. I mean, basically, the first time it was done, the controller said that was improper the way you did it.
Yes.
And then the next month, the controller, deputy controller signed a warrant doing the exact same thing that had just been previously.
What you're saying is that they had no authority.
That's right, and he's saying that they do have the authority, and I'm saying, well, if you have the authority, provide me with the laws and the legal authorities that support you. And they haven't given me that. All they do is twist my request, claiming that I made this ridiculous question.
I have a question for Ms. Zamuda, if that's okay. So I apologize. We're trying to kind of untie this. So it sounds to me like Mr. Clark, as Member Oka kind of pointed out, that it sounds like that, as far as I understand, he's claiming that the controller's office previously said you can't do X, and then a month later did X. And I'm just curious, I'm personally, like, it's a confusing issue to me. Do you have an opinion as to what Mr. Clark is referring to, that previously the controller's office said it was not able to do, and then, in his opinion, a month later it did?
There's a number of items that we looked at when we did the audit, and whether or not the fee structure was appropriate, and how often and when do you increase the fees. I don't recollect any specific warrant for some small $4,000 for a particular purpose, and it could be in there. I'm not certain, but so we did advise the commission that they needed to ensure that they would not increase fees if there was sufficient money in the next fiscal year to cover the cost of the program. It's supposed to be cost recovered. And you can have a balance to zero. Sometimes you have a little less or a little more. If you have a little less, they have to reduce spending. If they have a little more, they carry over that money, and they can pay for expenses in the next year. And in some instances, that prevents them from needing to increase the fee because they have money left over. It's called a continuing fund. And with a continuing fund, you can move expenses forward, you can move the dollars forward. So the board did not need to approve that expenditure. We've notified them earlier numerous times that's the case. And that's basically the way the program works. It's a very small program. I understand they're very invested in this particular program. We have spent many, many, many hundreds of hours looking at this small program, whether or not it's working. The Arts Commission did have some financial challenges over the years, on and off. They have much better financial controls now. And whether something happened back in 2008 is really, when we believe they had the authority, is really nothing that we're going to analyze any further.
Thank you.
And I apologize that we cannot, to their satisfaction, answer the questions, because we do provide financial advice and financial information to the public, to the departments, to the mayor, the board of supervisors. That is our job. And if we're not doing it satisfactorily, that is something that I would like to correct. But it's not for not trying. Sure. I guarantee you we have spent a lot of time with these two complainants about this particular issue. And I don't know that there's anything else that we can do about this particular topic.
Thank you. I have a question for DCA 3. So the difference between Ms. Immunity used the word, it's a continuing program, as opposed, and it doesn't need to go to the Board of Supervisors for supplemental funding. Can you enlighten us a little bit about what type of programs need to be need to be voted on for supplemental funding by the Board of Supervisors, and which type of programs do not?
Unfortunately, no, I cannot. It's not an area that I practice in.
Okay.
I have the answer to your questions right here in their own audit, the audit that they wrote. They stated that the San Francisco Arts Commission accounting session charged the Street Arts program for management and supervision charges that were unsupported by any SFA San Francisco Arts Commission policy resolution and were not communicated to the program's participants. The management and supervision charges were allocated to the program based on arbitrary allocation basis and were not discussed with the Street Arts. And then they go through in length explaining why why it was an improper charge. And, again, she's coming back up in front of you claiming that all we're asking about and discussing is whether or not surplus funds can be carried over to the next year. That is not even what the issue is here.
DC 3?
Through the chair, to Member David, perhaps a little more information. Mr. Clark's statements give me a little bit more information to work on. There are state laws that require that fees charged by city governments for purposes like this roughly match the cost of providing the services that they support. And if you do not follow the requirements for that, those fees can be challenged in court. And there have been a number of successful challenges throughout the state of California to local government fees on that basis. The Controller's Office also has a function to ensure that city departments are using best practices in achieving their goals, and one of those goals might be adopting fees. So the audit could outline ways in which they've fallen short of that, but that doesn't necessarily mean that the fee itself has no authority. If it still roughly matches the cost of the program, it may still be legal. So, there's a lot of issues in this, and it's a little bit convoluted in the discussion. So I'm not sure if that's helpful, but that's some more information.
Mr. Street, as I understand, what Mr. Clark is saying is that once a determination that something is not kosher, and that's my word, well, in one instance, and then a month later, that same thing becomes kosher. It's my understanding that if the Board of Supervisors has not appropriated funds or has not given authorization to do what to approve what's been disapproved without there being a hearing before the Board of Supervisors. As I understand it, that's what Mr. Clark is saying. And is that required?
So the controller, I haven't seen the report. I don't know what it says. So it's a little bit hard to answer the question on the basis of the assertions that are being put forward that are conflicting. So if the appropriation was approved by the Board of Supervisors and the money was carried over in the same fund for the following years because there was an excess, it had an appropriation that authorized it the year before. I don't know if that's the case or whether this is a new set of funds from fees that are charged in this year. I just don't understand the facts of this.
I can answer that, if you allow me.
Do you want to hear? What? Okay.
There was no management and supervision charge that was approved by the supervisors the previous year. Didn't happen. It was just charged us. I succeeded in getting that money returned to the Street Arts Fund because it wasn't proper. And then, like I said, after just 1 month when their audit was released, which I wish I had another copy I'd give to you, but I think she may have a copy of it. In that audit, the controller states that that was an improper charge because the method that was used was improper because there were no public hearings at any level. It was just done in the back rooms. And then we were charged that, and then the controller came out and said that was improper. And then all I'm saying is that 1 month after that report and audit came out, the controller signed another warrant doing the exact, charging us another $20,000, which we'll lose if we don't get it back. He signed another warrant charging us another $19,953, and the same method was used by the Arts Commission to come up with that number. There was never any public hearings, never went to the Board of Supervisors, and that's where the dialogue began between me and Leo Levinson and the Controller's Office. I began asking questions. And that's when I noticed also, because to be honest with you, Mr. Levinson told me that their system would not allow for a department to go over budget, that their system, I have other emails which I don't include in here. He told me that their system will not allow a budget to go over budget. And I said, oh, really? I said, well, then how come it went over budget? It went $4,000 over what the supervisors approved. And basically said, well, we're a special fund, and you've got surplus money, and you've got mid-year money, and you've got all this money, and we can pay for it, and it's okay, and we can do it, and everything's legal, and the city attorney is telling me that this is legal. And then I pointed out to the controller, it's hard to give you guys all this information, that I actually have a written city attorney opinion that states exactly what I'm saying needs to be done. I have a written opinion from the city attorney saying that that in order to make any other expenses from this program, before that can be done, it has to go in front of the Board of Supervisors for a supplemental appropriation ordinance. I pointed that out to Leo Levinson, and then he passed me up to Ms. Zamuda, and that's when I got the email back saying, well, we've already answered all your complaints about funds being carried over. That's when the twist happened.
Understood. Mr. Clark, how did you get the first $19,000 return? What was that process?
I had to go in front of the Arts Commission, to the Full Arts Commission, and get a motion adopted by the Full Arts Commission to transfer the money out of the Arts Commission's administrative fund back into the Street Arts Fund. The Arts Commission and the Controller did not do it on their own. I had to do it as a private citizen.
So are you planning on doing that again with this?
I've already planned on doing it, but they've refused to transfer it back, claiming that it's legal, that even though they used the same method, that they're not going to give that money back because the controller is now saying that the method that was used is legal. And all I'm saying is show me the legal authorities, and if I see if you've got them and you show them to me and they say what you claim they say, I'll agree and I'll stop it, but I don't believe they exist. They didn't do it. They just said, no, we're not. And like I said, they said, no, we're finished. Just like they're saying in here, yeah, we've had a lot of emails back and forth, but I think they've been very valid emails and statements and coherent questions and everything. And I reached that point where they distorted the issue and then said, that's it. We're not going to answer any more of your questions. And that's why I filed this complaint.
Okay, thank you. So, the question, once again, is the complaint is about the legal authority. So, it's not, I understand the history and everything, but I think, right, that's where kind of...
Yeah, where I'm stuck is, I understand Mr. Clark's frustration, and I'm wondering if this is truly a situation where two people are just looking at an issue and the controller's office is saying they honestly believe they're answering the question, and Mr. Clark honestly believes that they're not answering the question, right? And that.
Can you say that when I'm standing here telling? Excuse me for interrupting, but this is.
Sir, I understand. I know it's very emotional for you. I understand. Well, because I do understand how there could be a misinterpretation of understanding what it is that you're asking for, the legal authority versus what the respondent believes you're asking for. So my question basically is, do you understand what he's asking for, the legal authorities, what's the law, and is there some public records that indicate that you can give to him indicating what the legal authority for the controller, for the body, the Arts Commission stuff that he's talking about? Or can you go to your...
The citations that I've made in the previous emails underscore the legal authority for spending the funds. So that's one issue, and I think that issue is closed. The question as to whether or not the Arts Commission can charge administrative overhead to the Street Artist Fund is a separate issue. We did do an audit. We did find some allocation methodologies that were inconsistent. We did recommend that the Arts Commission staff correct those misallocations. Now, if I can commit to this, that I can go back to the Arts Commission staff, the finance staff. I can try to find the transactions that he's complaining about, and just to see if it is, in fact, exactly the same as the one that was cited in the audit.
Okay.
And I can report that back to him.
Okay.
But the continuous question, and even if you look at your agenda, it's that we didn't provide any legal authority about their being able to spend surplus money without an appropriation. We answered that question many, many times. And so if you wish, I can commit to this committee that I will go to the Arts Commission next week. I will try to unravel what that transaction is and to see if it is exactly the same issue as was cited in the audit.
Okay. Thank you. At this time, I would like, I'm sorry, Member Washburn.
To make a motion.
Yeah, that's what I was going
I think what Ms. Samuda just said clarifies everything for us. In rereading the original request, I believe that Mr. Clark was pretty clear about what he wanted. He was referring to the audit that even the controller helped get the money back for the Street Artist Fund, and the same issue came up. And I think it was clear what they were asking, and if it wasn't clear, it's up to the department to ask for some clarification. Is this what you want? You work with the requester to make sure you understand what it is they're requesting. So I'd like to make a motion to find a violation of 67.21A, and actually 67.21B. And possibly, I might need some help from DCA 3 about release of oral public information. This might have been a situation where there's no document that would answer the question. It's oral information, whether there could have been a violation of 67.22. Does that make sense? 6722A.
Through the chair, to Member Washburn, if you're asking me whether that may apply, in my opinion, I can provide that answer to you. Is that what you're asking?
Yes.
So it's 67.22 specifically covers situations where a department can designate a person to answer questions about the department's operations, plans, policies, and positions. It's not a general provision that requires that information be provided orally when requested of any employee of the department.
So through the chair, could 67, DCA 3, could 67.22B apply? That given that there is such a person, that person should provide information.
6722B or 21B?
Well, actually, I'm looking at both. The issue is that there's some information that was requested. It was either something, say, an opinion from the city attorney about this matter, or from the auditor, but in the absence of this written public record, there might have been information, knowledge in the controller's office about what was done here, and that would be oral communication that could have happened. So that's why I'm saying, including both 6721B and 67.22B.
So if you look at 6722A, it talks about that designated person and what they should provide if they're designated, and that's the department's operations, plans, policies, and positions. 6721 deals with providing public records or public information, and if you look at the definition of public information in 6720, it means the content of public records as defined by the Public Records Act. So to the extent there's a public record that would have answered that question, Ms. Zamuda would be obliged, absent any exemption from disclosure, to disclose what was contained in that public record.
Okay, so 6721B would be for sure.
Yes.
Okay, all right. I move to find a violation of 67.21B.
I second that.
It's been moved and seconded that the controller has been in violation of the sunshine. Can you read the actual ordinance, Madam Clerk, please? What we just moved and seconded. 21B. Okay. And is in violation of Sunshine Ordinance 6721B.
Right.
Okay, great. Is there any public comment?
For someone who has not offered facts.
If not, no, then I would like to take a vote. Can you do a roll call vote?
Through the chair first to Member Washburn, 6721B, but the facts and findings supporting that, could you repeat that?
That the complainant requested information, in particular legal authorities, that would support an action by the Arts Commission, wanted information from the controller about an action by the Arts Commission regarding some money that was budgeted for a particular purpose. And this information was not given to the respondent in a timely manner or at all.
Thank you.
I think we can be more specific about that.
And
it's about the legal authority for budgeting money for managerial fees after this particular method had been found improper by the auditor in a previous year.
Is that, I'm sorry, hold on one sec. So is that everything that you want to include in there?
Right. I think the order of determination can
be more specific. Yeah, I can get more
right.
specific about what. Still confused.
But that's the particular information that was not given.
Okay.
In violation of 67.21B.
So should we comment, or do we want Samuda to comment?
Well, we were going to take a roll call vote. Do you guys have some questions?
Yeah, I got a question.
We do.
You know, point of order. I just don't think I'm really there yet. This is the last thing you probably want to hear, but I would like to maybe send this to Compliance Committee or something to investigate
Which is what we can do with my order of determination. So just by taking a motion that they're in violation, and then this can be sent to, which I can do as an order of determination.
Okay.
Can be into
So
education
it's
training.
not a death sentence.
Number 3.
So just to be clear, if the order is approved, that's a finding of a violation. So the investigation essentially would be over about whether there was a violation. That would be a finding by the task force that the respondent violated the ordinance. So if any member has questions about that, the answer is not to send it, to approve the order and send it for further investigation. It's if you don't believe there's a violation, or if you're unconvinced, then you have you have two options. You can vote for the motion if you believe there's a violation, or you can vote against it if you have questions or you're unconvinced.
Great. So can I do we're going to do a roll call vote on this. Oh, I'm sorry, you have a question?
So I just want to, so I would like the end result of this is I would like to see the clerks get the information that they're looking for. Okay. I do not believe that there's been a violation. I think the appropriate thing would be to send it to a committee, to one of the committees, to get, so I just want to know, I guess what I want to make sure is that if we're voting on it, there's a violation, and it does not get 6 votes, it doesn't leave open the option to send it to a committee afterwards, right? That would close that would close it.
I don't think it would.
This is why I want to ask, right? Yeah.
So there's really two different issues there.
Okay.
On a complaint before the task force, on that matter, the task force makes a decision, or sometimes doesn't make a decision, and then it dies for lack of action. But that ends that complaint. That does not prevent, however, the Education and Outreach Committee from putting an item on the agenda about procedures under the Sunshine Ordinance for any department, and inviting that department to come discuss that matter with them, and to talk about whether the procedures that are in place are sufficiently transparent to the public. But the complaint itself would be over after the action, unless if the task force finds a violation, then it continues through the enforcement process.
Member Washburn.
I just wanted to say that what we're saying by, what I was intending by this motion, that there was a violation of this part of the ordinance, is that we believe that there is some information, public information, pertaining to this allocation of money. And we believe that this information was not provided to the clerks. So, therefore, there's a violation of the ordinance. Now, it could be that there was a miscommunication, and that the failure to give the information was not, it wasn't a crime of any kind. But the fact is that there is some information and it wasn't provided. So if you vote in favor of this violation, it would go to compliance and amendments. And the order of determination will order the respondent to provide the information. And then let's hope by the time this committee meets, CNA meets, the matter will be ended. That's the outcome. But if you believe that there's information that hasn't been provided, then it would make sense to vote for this motion that there's been a violation. It's kind of the rock bottom of what we do. There's public records and they haven't been provided. So
yes, you can. I'm sorry.
If I might, there are no public records that respond to this inquiry. There are auditors, there are analysts, there are accountants that would have to take time away from their regular work and dig this up. There's no one in my department that knows the answer to this question. And there is legal authority for them to spend the amount of money that they spent with the revenue that they had. We made that very clear. That was the question that was raised. Did they have the authority to spend beyond their budget? The answer is yes. And I spoke to the city attorney, I looked at all of the citations, I looked at the request. Now what you're hearing is that he believes that there is an audit finding from many years ago about an expense that maybe had been allocated or maybe not. That's not a public information request. That's an audit finding that takes time and effort in order to do. The Sunshine Task Force is not, frankly, able to tell us to go do an audit. Now, we may, because this is such a continuous problem to the complainants, to the Arts Commission, to the Controller's Office. I mean, that's why we did the audit in the first place, because there were a lot of complaints, there were a lot of issues, there were some problems in the accounting in that department. We thought that there were risks there, and so we went ahead and allocated staff time to do the audit. Now they're saying that there's a similar finding in a subsequent period. And again, I'm committing to you, I can look at it, but I assure you this is not a violation of not providing existing information, not providing knowledge, not transferring knowledge. This is a totally different problem that we have.
Thank you. Member Washburn?
Ms. Samuda?
Yes, Ms. Member Washburn, then I definitely will let you respond.
Ms. Samuda, when you received this, when this request was received from the clerks, did anyone respond to them the way you just responded here, that that information didn't exist, that you would have to do an audit? I mean, that's the way to handle a request. When a member of the public requests information and that information doesn't exist, then to comply with the ordinance, you must tell the member of the public, there is no record that's responsive to this request. We cannot answer that. That's another violation of the ordinance.
Extremely familiar with this ordinance. We respond to hundreds of requests a year. I know that we need to provide information in a timely way, and if there is no information, we need to say so. There are times that we actually run reports in order to get the information, because we run an information system that has hundreds and thousands of transactions in it, and we can't just pull something out. We have to run a report. We spend a lot of time and effort trying to meet the needs of the public. We have spent a lot of time and effort on all of the requests of these two complainants. It had never been articulated to me or to Mr. Levinson exactly the transaction he was doubting or questioning. And, maybe that would have saved us all a lot of time. But he was continuously challenging whether the department had the authority to spend that money. Yes, they did. They were within their appropriation limit. So, this is up to you, and you're authorized to make this determination, and I will abide by what you say. But I do want you to consider from the controller's point of view. We do hundreds and hundreds of these a year, and we try very hard to meet the need of the request in every instance.
Thank you. Mr. Clark?
Briefly.
Please.
They told me they had legal authorities that supported their right to charge that second management and supervision charge. The month after, they told the Arts Commission that it was illegal for the Arts Commission to do that. They said they had legal authorities supporting their right to charge that and cause the budget to go over what the Board of Supervisors voted to allocate to them, without having to go back to the Board of Supervisors. They're the ones who claim they have the legal authorities to me to do those things. And this has nothing to do with an audit. I'm not asking for an audit. The audit's been done. The audit is self-explanatory. They're the ones who, when I asked, how can you do this after you just told the Arts Commission that it's illegal to do it? They're the ones that told me, well, they have the legal authorities. I looked through what I could find, sent it to them, and I said, this all says you can't do what you did. They said, well, we have the legal authorities. So they're the ones claiming that they have the record, whether it's information, public record, that supports what they claim they're doing. And now she's standing up here saying that they don't have any record. There is no document. There's nothing there saying it. So, I mean, if they had come out, like you said in the first place, and said, well, there's nothing supporting us and we're wrong, then I could go and get the money back like I did the year before. But they're the ones claiming that there's legal authorities allowing them to do what they're doing. So please, help me either put them to the test and either provide me with those legal authorities or actually say, well, you know, there are no legal authorities and we don't know what to say. And the only way to do it is for you to find them in violation and send this to committee and give me an opportunity to further prove to you that either those legal authorities exist or they don't exist.
Thank you. There is a motion on the floor. Is the task force ready to vote on this motion? Great. Madam Clerk?
Member Monet?
Pass.
Member Washburn?
Aye.
Washburn, aye. Member Sims?
Aye.
Sims, aye. David?
No.
David, no. Highland?
Aye.
Highland, aye. Oka?
Aye.
Oka, aye. Fisher?
No.
Fisher, no. Monet?
Aye.
Monet, aye. Chair Grant?
Aye.
You have 6 ayes and 2 noes.
I'm sorry, say it again. Can you?
6 ayes and 2 noes.
Great. So the motion passed. I am going to recommend that we send this to Compliance and Amendments. When's our next meeting? February 19th, I believe. Whenever the next Compliance Amendments meeting, I will get that date to you, and hopefully we can. Number 3.
Through the chair, in order to be heard by the Compliance and Amendments, just a sort of procedural note, you will have to have issued the order to the department before that time.
Okay. So I will issue that order. I don't know if it's going to be by February 19th. When is the next one?
The next Compliance and Amendments meeting is February, hold on, the 19th.
Okay,
So I don't think you would have.
Yeah, so I won't have it by then, but by the March compliance meeting, we will issue that and then hopefully be able to come to some sort of solution and answer the question that Mr. Clark is trying to get the answer to. And hopefully we can mediate and maybe not have to deal with it. So thank you very much. At this time, I'd like to take a 10-minute break. And come back after that. Thank you.
Pardon me?
I mean, I recognize him. I don't know him. He wouldn't know me from. He might recognize me.
Apparently not the blush bar anymore.
Well, we had a number of cases against him, actually, against his office. Yeah.
It's.
No.
I think you nuts.
I got lost.
Oh yeah, about.
I know. All right. I know. I never bring. Too busy.
I'd like to call this meeting back to order. Madam Clerk, can you read file number 12039?
Item number 6, file number 12039, complaint filed by William Clark against Monique Zamunda, Assistant Controller, for allegedly not providing response regarding Arts Commission street artist funds in the fiscal year 1990, fiscal year 2009 to 2010, and fiscal year 2010-2011.
Thank you. We are going to, well, actually, jurisdiction has been accepted by both parties. I need to get a motion and a second to accept the jurisdiction.
I'll second.
Well, nobody made a motion yet.
Oops. I was so excited.
So you can make a motion.
I'll make the motion to accept jurisdiction.
Do I have a second?
Second.
It's been moved and seconded, and this motion passes without objection. Mr. Clark? I'm sorry.
William Clark again. Thank you for taking all this.
Oh, yeah, that's right.
I'm William.
Okay.
I'll try to do this very briefly and coherently, but this is basically based on 3 questions that I asked Mrs. Amuda to respond to, which you all read. I'm sure it's here, so I don't have to redo. This comes as a result of discussions regarding this year's budget and the use of surplus funds. This goes directly to the issue of surplus funds and the cost of a street art certificate fee. The controller has consistently, first let me make you aware of this. There is a section of the Street Artist Ordinance, which is section 2404.2, which is called the fee setting procedure. And in that fee setting procedure, it states that every year that the Board of Supervisors and the Art Commission readjust the street arts fees based on how much money we have left in surplus and how much our expenses are going to be here for the next year. Consistently, the controller has several times refused to use the surplus when calculating the street arts fees. At the end of each year, at sometimes in the past, which my questions are in reference to, there have been large surpluses remaining in the street artists fund. At sometimes there's been as much as $150,000 in surplus. The way the procedure works is that at the beginning of a fiscal year, the Arts Commission is supposed to take whatever money is left in the fund and then apply it to the next year's expenses. So if the next year's expenses are $250,000, and there's $150,000 remaining in the fund at the beginning of the year, then the Art Commission only has to raise $100,000 in certificate fees to pay for the remaining expenses for the next fiscal year. So we divide the number of people that are into the program into the amount of number that needs to be raised as revenue, and that gives you a number that's the new street artist fee. And for years, even up until this year, the controller has been withholding those surpluses, and in the last year, in this present fiscal year, we wrote back and forth, and the controller explained to me that, well, this year we're going to use up all the surplus at next year, so we'll apply it to next year's expenses and to the expenses of the Street Arts program. So what I did was I wrote these 3 letters based on the fee setting procedure. I asked them, if I said, well, actually what I said was, I know that's how you do it, because every year we do it the same way. We've been doing this for 40 years. Every year, money that's left over at the end of the year carries, contrary to what she claims I'm saying, every year it carries over and is used to pay for the following year's expenses. But they have been refusing to use it and instead making the street artists pay all the expenses through the certificate fee. So the 3 questions I asked interest were based on prior history. In the past, there was, from 1991 to 1997, a surplus of $150,000 accrued to the program. And the controller did not carry that money forward and use it for the expenses in 1998. So what this is about is, since she's explaining to me that this is how we're going to do it in the future, we're going to carry forward and use it to pay for the following year's expenses. I just asked them, well, why didn't you do that in 1997 when you had $150,000 left over in the fund? Why didn't you carry that money forward and count and use it as revenue for the next year? And instead, our fees were raised, even though we had these large surpluses. I've been arguing for years that they've been not applying the proper procedure to calculating the street artist fees. So, and then we also found out that the controller's office had been taking all the interest from all the special funds in the city and improperly putting them into the city's general fund. And so my second question was addressing the interest, because I have a document from the controller stating that they misapplied the law, and they took all the interest out of all the special funds, including the street artist fund. And then my third question was self-evident. I'll let my brother finish.
Thank you so much. Anyone facts and evidence for the complainant?
He brings a spare.
Hi, Robert Clark. You guys are lucky we're not triplets. My mother's lucky we're not triplets.
Yeah.
Okay, what I'm going to just try to finish it out. Because, see, what happened is a few years ago, I think it was around 2000, we were trying to get our special fund with all our interest to be put into our special fund. And we succeeded in doing that. And in the process, we found out that the controller made a statement, had changed the whole section on special funds and interest. And we went down into the Board of Supervisors and we got the file of the papers. And sure enough, on the first page of the files, the Board of Supervisors said, well, you're coming in here to change this whole section. There's got to be a reason why you're changing this section. Otherwise, what are we doing here? And the controller got up there, or I should say, the deputy controller, I believe it might have been, I'm trying to think of the name, Ben Rosen. I think it might have been Ben Rosenfield, but no, it was the other guy. But anyway, he got up there and he said, for all these years, we've been assuming that if there's no language in the law that says we can't take the interest out of the special funds, we assumed we could. Now, it turns out it's legally the exact opposite. The law is that if there is no language in the ordinance that says you can take the interest out of the special fund, you can't. And so we discovered that the controller was creating this whole restructuring of the section of the law so that he would no longer be violating the law, because all the special funds had no language in there saying that they could take the interest out of it. And in the process, we found out that they were taking our interest out of the special funds. And so this is one of the reasons why this whole thing started to develop. This is why they created the surplus. We're saying the surplus at the end of the year, contrary to what she's saying. We've been arguing for years. No, you got to take that surplus at the end of the year, apply it to the next year, and lower the street artist fees. And we're trying to figure out. The controller and the city attorney say, no, you can keep this surplus. And so we determined, no, the reason why they were telling them that was because the city attorney was taking all of our interest out of our special fund. So if it goes up to $150,000, it sits on $150,000. Well, guess who got the interest to that special fund? The city took the interest to that special fund. And so that's why these three questions were asked to this particular person, and she wouldn't answer them. And basically, all I'm saying is, is that the controller, we have evidence that the controller violated the law, and the controller apparently doesn't want to self-incriminate themselves.
Thank you. Ms. Zamuda, if you can come up, please. Thank you.
I mean, I think I've said everything there was to say in the last item. This is 1997. There really was, if it was silent, it was the practice of the Comptroller's Office way back there 17 years ago to take the interest in these funds. They're city money. So since that time, it was clarified, and it is an interest-bearing fund now. Yes, they can move the money forward, and that if there is a balance, it prevents need for increased fees. I stated it. I've responded to the questions. I don't see any response or any documentation or anything like that that we have not provided.
Thank you. If there's anyone here with any facts or evidence for the respondent, I'd like to open it up to the task force for questions. Anyone
I'd like to start with the Clarks. So,
I'm joking.
So William, right?
Yes.
Yeah. So I'm reading the questions.
Right.
Right. And I don't, where I'm kind of a little bit confused about why this is in front of the Sunshine Ordinance Task Force, you're nowhere in your questions do you request documents.
No, I'm requesting information. Public information.
So what documents would you like Ms. Zamuda to be providing you?
None. I want information. I want the answer to these 3 questions.
Okay. Thank you.
I have a question. So your question number 2, was it because, I mean, what was your reasonable expectation of the answer? Was it because the city was illegally taking all the interest which accrued?
Right. The reason we asked the first question, why didn't they use the surplus, the $150,000 surplus at the end of the year to use it to readjust the street artist, basically to use it to readjust the street artist fee? And why did they withhold the use of that money for the next fiscal year? And then, obviously, the second question is a little forward. And was it because they were taking all the interest? I mean, they were getting all the interest. Every time we had a surplus, they were getting all the interest. And it's a straightforward question of, did they withhold the use of that money and prevent us from using it for the purpose it was intended by law, which is to pay for the next year's expenses or to lower the cost of the street artist fee? And did they do what they did because they were getting the interest? Whether they knew that it was legal or not legal, was that the reason why they did that?
Thank you. Member Washburn, I'm sorry, Mr. Clark?
Mr. Clark. So, on August 16th, 2012, you sent an email with the 3 questions.
That's correct.
And how did Ms. Zamuda respond to you? Or how did anyone from the Comptroller's Office? What happened next?
I believe they said that they weren't going to respond any further to me. That the issues they weren't going to respond at all anymore. I think I have it in here on one of the emails, but to paraphrase it, they said, we're through talking to you about this matter.
Yeah,
we've done. It's done.
Just I can read it. I have it right here. On August 17th, she's Member Washburn. She said, Mr. Clark, from Monique Zamuda, Mr. Clark, the Comptroller's Office has responded to your questions and considers this issue completed.
Right.
So, Mr. Clark had...
And then
the next
give you
day.
the next, she gives you a little bit more on August 16th. I'm sorry, I think I'm going backwards.
Yeah.
Yeah, I'm starting at the bottom.
And then the next day, I respond and say, well, you didn't answer the 3 questions, which I asked.
But, I'm sorry.
No,
I don't know if Member Washburn is finished.
Because you want to see what she said, and this is, let's see, if we go back for 1 second, you can see what the response, just to be fair to both parties. If we get the first, so the first document is, if I'm not mistaken, is from November 8th, 2012. Is that right, Mr. Clark and Ms. Samuda?
Which the first time is on what now?
November 8th, you have a response from Monique.
All the way back.
Yeah, if you started, she goes into a kind of extensive about the Controller's Office responding again to your continued complaint and disagreement regarding the authority of the Arts Commission to expend funds appropriated in a prior year. As we have reported to you in the past, as a general rule, departments may not spend special fund proceeds unless the Board of Supervisors appropriates such funds. Is that correct? In the biennial appropriation ordinance. And then,
in other words, she said exactly what I said in the other case. She's arguing against herself, what she claimed in the other case. That's the email where she says that they have to go in front of the Board of Supervisors and get a supplemental appropriation. I'm looking for the November
8th, and then you respond November 9th.
Right. I believe that email was referring to the other case, that particular email, but it's also there's the one in here. I'm just looking for, because the last email I got on this case was the one that we just said, which was in August. I believe the email you're reading refers...
It's from file number 12039.
Yeah, I think she misnumbered it.
So the documents that are in 12039 are incorrect?
No, that particular letter, I think, referred to the other complaint. It's because it has nothing to do with, okay, they're going to respond. Because, this I have here. Oh, gosh, I'm sorry for taking so long. Mr. Clark, blah, 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 blah.
Madam Clerk, can you look in there as well? And just tell me if these documents are the ones.
Okay, I see the one. This is the one the Controller's Office responded again to your continued complaint. Right, okay, that's on November 8th, right.
Yes.
Okay, now
so these are correct documents.
Since she put them in both cases then, because it was referred to in the other case. But regardless of that,
so it's
go
the same.
ahead.
Okay. So it's the same thing. So they did, my point is they did have continual
yeah, and basically all this is saying is that it's appropriate to take money left over at the end of the year and use it in the next year to pay for the next year's expenses, which we've been arguing for thousands of years. But we're saying that it's inappropriate to withhold the surplus from being used the next year. And that's what's been going on is that they've been withholding large surpluses from use instead of carrying them forward, which she says should be done. I agree, it should be done. In the past, the practice has been to withhold up to $150,000 at time, and then to charge the street, or instead of using that money on the next year, they charge a street art's fee to pay for all the expenses for the next year. And that's why my question is related to, are you going to use that money in the fee-setting formula in the future? Because in the past, they have refused to use surpluses in recalculating fees the next year. And in some cases, if they had done that, the fee would have been lowered, because we had more than between the surplus and what we would charge street arts for an annual fee. We would have to lower the fee because the city is not allowed to charge more than what it has to pay for expenses for each fiscal year. So we're saying, well, great, if you're going to do this, why didn't you do this in the past? I mean, you're saying this is the law. Why didn't you do this? Because if they did that, we would have had our fees lowered several times instead of having them raised several times.
I understand what you're saying. I guess my
question is from the complaint. The three, once again, I'm trying to stick to the issue at hand, is that you asked these three questions.
Right.
Are those three questions public record? To me, they're very kind of her opinion. It might be in the way that you phrase the question. So I don't even think I'm concerned that this is our jurisdiction of.
Procedure.
Is it illegal? Is it those kinds of questions, these types of questions that you're asking?
I understand your thinking, and that's for you to evaluate whether or not I have a right to know why they didn't do what they claim is the legal thing to do now, and I'm just trying to get educated as to what method, why didn't they use that method in the past? And like you said, I don't know whether that's appropriate.
Yeah. Member Sims?
I think Ms. Zuma. I aware that Mr. Clark asked you a lot of questions. That I do feel like you do your best to try to answer them, and I think that he definitely did ask three questions, and those three questions, one related to the 1990s with no specific date in the 1990s, just the 90s, and then one was more an allegation than a records request. So I really can't hold you for answering that. But the second one was also a valid question regarding a more specific date, fiscal year 2009 to 2010 and 2010 to 2011. So I don't see your answer to those three questions. Let's say the middle one, the second one, isn't a question. I'll throw that out. That's not a question. That's not a public information. But you could have responded to that if you wanted to and said, we have no information regarding that, the legality of that. But at least to the 1990s, you could have, because it's public information, you have the oral communication within the, and the means to at least find if there is any public record or any oral communication within the department that could answer his question, or direct him to a staff that could answer his question. So I guess my question for you would be, why didn't you answer the 1990s if you didn't have any information? Just say, I don't have any information regarding that. And why didn't you answer the third question, which is regarding fiscal year 09, 010, and 10, 11, which it seems like you would have information or readily available?
The questions are about policies and procedures that were enacted about a certain transaction. In the 1990s,
No, and
maybe the Clarks were here in the 1990s. I was working for the city in 1990s. I was not working for the Controller's Office. We had a totally different system. They are very argumentative about the way they believe this fund should operate. And as the financial officer of the city, we monitor this, and the funds were operating in accordance to the generally accepted accounting principles. And I don't know that there was $150,000 left. They say that there was, but I don't know that that's the case. And it's analysis. It's a huge amount of research that we don't have documents. We don't have the memory. And it's a dialogue that literally goes on for years and decades. This is not a public records request. This is not the press asking us how much money people make or what about this transactions. I can't look into the system and answer his question. It is an untenable situation for the Controller's Office to be responding to theoretical, potential, somewhat with a little thread of accuracy and a lot of misunderstanding, many accounting-related questions from 10 and 20 years ago. We had been communicating for years. We did the audit. The methodology was being questioned by the Controller's Office. They changed the methodology. They were constantly asking questions whether the Arts Commission had the authority to spend certain money. We looked at that question. We answered yes that they did. They're questioning about prior year money and whether or not that could be used to roll over to reduce the fees the next year. We said, yes, that can be done. I don't know that there's any more that we can do. And the more we respond, the more questions they have about theoretical or potential issues. We cannot spend lots and lots of accounting and auditing time auditing a program that they don't agree how it operates.
Ms. Zuma, not to stop you, but to stop you.
Okay.
I think my question is, you partly answered my question. In regards to 1990s, it seems like your answer was, we don't have any information regarding that. I don't have any information regarding that. I don't have any staff I can direct you to. But you readily, easily said that here, but you didn't say that to him. So, but you understand that as a city employee, you have a duty to say that to him and respond, correct?
I know that I need to respond, and I do believe that I responded many times to the same types of questions asked many different ways, as evidenced by how confused all of us were about an hour ago. And so it is not an easy thing to do, and at some point we have to say, we have responded to your question. The answer isn't going to change.
I understand that, but I don't see that response here. And I feel like at least to the 1990s question, you had a duty to respond. And the response could have been, I don't know. The response could have been what you're giving me now, which you could have said in really a sentence. And like I said, to the illegality, interest, and all that was more like an allegation versus a question. But now let's go to the more specific question that he makes. Regarding 2009-10 to 2010-2011. Because I see a response that you make when he asked, I think it was regarding a previous year, maybe 2010-2011, 11-13. Your response previous to that is in regards to 11-13. I mean, it sounds like that response, which is directly underneath it in our paperwork, could have easily been your response to 09-010, 010-11, which would be the same thing. And Ms. Zumuda, my apologies. I feel your frustration because I know it seems like you have to respond often to Mr. Clark, but he, as a member of the public, deserves a response as long as you're able to give it to him with public information at your disposal. Exactly.
If I have it, and
then say it.
We have done way above that. We have audited, we have discussed, we have debated, we have analyzed. At some point, we have to say this is not worth the time of the Controller's Office, whose responsibilities are very huge over many things that are much more important. I know this is important to the Clarks. This is their livelihood and so forth. We do not believe, after looking at this, that this program is not operating. We believe it's operating properly within the confines of the fund, within the appropriation limits, and they don't agree. And it's very hard to continue to dialogue and to provide more explanation because it opens up the debate. This is a debate. This is no longer a request for public information. This is a debate as to whether or not the interpretation of the controller about a certain appropriation is in agreement with theirs. I'm sorry. It really has taken months and months and years on this issue, and and the controller agrees with me. I've had to take my staff off of these complaints because they were spending inordinate amounts of time. And we need to let the system work. And if he's not in agreement with the way the program is organized, then there are ways of changing the program through legal means. It's not asking the controller theoretical questions about accounting practices of 17 years ago.
Thank you. Oh, Member Washburn?
Ms. Amuto, I understand what you're saying, and I hear how frustrated you are. But just looking at this specific complaint and the three questions, I can't tell from the packet that I have, and I'm looking at the electronic copy, when it was that you responded in the first place and what it was that you said. I have the three questions from August 16th, and then on August 17th you say simply that the Controller's Office has responded to your questions and considers the issue completed.
Mm-hmm.
So did you at some point say that you didn't have any records responsive?
Mr. Levinson had an ongoing email dialogue, and there were a lot of questions that were being requested and responded to and so forth about how the fund works, whether the money carries forward, and so on. And we responded to those questions. And so, no, when I saw those from the 1990s, I mean, no, I didn't respond to that.
Are there any more questions? If not, I'd like to know if there's a motion to find a violation of the Sunshine Ordinance.
Or response.
Did they do it? We didn't do
No,
the
they
response?
didn't.
Oh, I'm sorry. I thought we had.
Only if there's a motion.
Only if there's a motion. Gotcha.
So we're just at the response.
I'll try.
I apologize.
No, that's okay. That's okay. First of all, I want to remind you, this is not city money we're talking about. This is the street artist money. These are public funds, but they are monies that are held in trust for the administration and enforcement of the street artist program that is contributed by street artist fees. So, of course, the city isn't as concerned about it because it's not their money; it's our money. And now I want to point out to you that I have been keeping track of all the money from 1972 because I started the street artist program, and I've been keeping track of all the funds. Since that time, I have found over $130,000 that was being withheld from our use, including the $20,000 management fee, which I've had returned back to the street artists. And I've also found over $250,000 that was taken from our fund and put on the general fund and used for general municipal purposes, which was an illegal tax of the street artists at that time. The city does not want to acknowledge that the street artists that the city has taken hundreds of thousands of dollars and withheld it from use. And I'm not just talking willy-nilly about what I want and arguing with it. I'm talking about what the law says. The law says in Section 2404.2 of Article 24 of the Police Code that there is a fee-setting procedure, that every year the controller and the Arts Commission have to calculate a new fee. And incumbent in calculating that fee is to carry over funds that are left from the prior fiscal year when trying to figure out how we're going to pay for next year's expenses. And if we're lucky enough to have surpluses carried over, which at times we have had as much as $150,000, then that money is supposed to be used the next year. But what's been happening is the city has withheld the use of that money for sometimes as much as 10 years. And the controller does have the records and the files of the 1990 money that I was talking about because they were the ones who kept the surplus and kept control of the fund. So it's not hard for them to find that. They do have all those records. So what I'm saying is that these records are easily available, and all I'm asking, I appreciate what you guys are saying about the second question. I admit it was a little, my lawyer in me, I guess, thought I could take a punch at it, but I do feel that my other two questions are valid. I want to know why they did one thing one year and not do it another year, and why they withheld the use of these large surpluses and raised our fees.
Thank you. You have a question?
So Mr. Clark, I have to say that it feels to me like this is a policy issue. And I guess my question is that why did you not request in your sunshine request documents from 1990, documents
because I already have them in my possession. I have all the financial documents from the Art Commission and the Controller.
I mean, it feels to me like you're coming to the Sunshine Task Force and asking us to make a decision on policy. Like that's how it feels. Is that I'm not sure.
Yeah, well,
if you say you have, if you say
it feels to me that you're always accusing me of things that I'm not doing. All I'm trying to do is, when I'm told by them one thing, that they're doing it this way and they're doing it lawful, and I've found them withholding and taking large sums of our money and preventing us from using it and concealing that from the public, and I'm trying to bring light to that fact, and I'm asking them, well, if you did this in this one occasion, why didn't you do that in the other occasion? Because that's the law. And like I said, just the one answer. I've shoved in their face the fee-setting procedure. Every year we go through a budget, and every year they withhold our surplus, and every year they raise our fees. And I say, well, look, the law says that you're supposed to use this surplus in calculating a new fee. And they just disregard it. They say, well, we could either raise your fee or we could lower your fee. And they withhold these large sums of money and raise our fee. Matter of fact, we're going through a big fee raise now. We're going to have our fees raised $180 a year because they're running at a $66,000 deficit. This year, we are being told that next year our fees are going to be raised another $180 a year. And this is because of the mismanagement of our funds. So all I'm trying to find out is okay, you say policy, and I agree, method, policy. I'm saying, well, why, if you're telling me you're following the law doing this, well, why didn't you follow the law in prior years and do that same thing?
But all we're empowered to do as a task force is to say, please provide the person with the following public information if it's available.
I have no problem with that. So they did it, so wouldn't they know why they did something? That's all. Okay.
Thanks.
Okay.
DC3.
Through the chair, it would have been helpful to have a little more information in analyzing this complaint earlier, so apologies for not addressing this in the memo. It appears clear to me at this point that the request is for information that's not in the public records, because Mr. Clark says that he already has the public records. He's seeking information to explain some of these policies. And look through that lens, the three questions are essentially interrogatories to the controller, asking for them to provide information that's not in documents. There's case law under the Public Records Act that says that the Public Records Act does not require any department to respond to a public interrogatory. And if you look at the definition of public information in the Sunshine Ordinance, it says the public information shall mean the content of public records, which means it's essentially the same definition as in the Public Records Act. So that's just additional legal information. There still remains the question that I believe members of the task force have been asking about whether there was actually any response to the request that addressed the specifics of the request.
Thank you. Are there any more questions? Ms. Samuda, would you like to offer conclusion or anything at the end? Okay. In that case, I'd like to know if there is a motion to find a violation of the Sunshine Ordinance.
Well, I'll make a motion to find a violation of Sunshine Ordinance. I guess section 67.21B, for failing to answer, I will say, 2 questions made by a member of the public. Yeah, I guess that's it.
67.21B, is there a second? Member Washburn?
A clarification. I want to know if Member Sims is thinking that the respondent didn't indicate to the complainant that there was no public record that was responsive to these questions.
Yeah, so you're correct. So maybe
Okay.
I think maybe it should be 67.21E then, I guess, fails to comply or incompetently complies with the request.
Is that what you're going to,
Yeah.
67.21E?
Yeah.
Yeah, that makes sense.
Am I?
DC3?
Through the chair, 6721E is actually although it starts out with that phrase, what it does is set out the procedure for bringing a complaint to the task force.
Okay.
The basis for the complaints is set out above that.
Okay. So so then it would be. It would be B then.
Yeah.
Yeah. Okay.
So it's B, as in boy.
Yeah. So it would be B.
Cool. Is there a
Bill and
second?
Bob. B as in Bill and Bob.
Is there a second to Member Sims' motion?
I second it.
It's been moved and seconded. I'd like to open up to public comment.
This issue has been so much of the street artist program for so long. There's always discussion about it in the lottery in the morning. There's always some chatter about it throughout the day because you're required to sell in certain areas of the city which are set for street artists. So there's usually groups of people. And it's been going on for so many years. And it's basically a lack of information. It's just so in the way of what this program is about. You're just supposed to go to the lottery, get your space, and go out to work and make your little things. And this chatter or this rhetoric has gone on for so long, and it's particularly relevant now because they're raising the rates. And there's a lot of angry people that don't really get a clear explanation as to why the fees are going up. It expresses itself in a lot of ways at public hearings where people seem to make threats to the Full Arts Commission or out on the street. And whatever your ruling is, if it could just be made public so people know and understand what is going on, because they lay blame on certain individuals. And it doesn't sound to me like that's the issue here. Thank you.
Thank you. If there's no more public comment, Madam Clerk, I'd like to take a vote. Roll call.
Member Monet?
Aye.
Monet, aye. Washburn?
Aye.
Washburn, aye. Sims?
Aye.
Sims, aye. David?
No.
David, no. Highland?
Pass.
Member Oka?
No.
Oka, no. Fisher?
Really torn. Can I pass?
Member, excuse me. Member Highland?
No.
Highland, no. Member Fisher?
No.
Fisher, no. Chair Grant?
No.
You have 4 ayes and 4 noes.
Thank you, members.
Thank you.
I'm sorry. You said Grant, you no?
No.
No, I'm sorry.
With 5.
So, yes.
With 5 no's, right?
With 5 noes and 3
3
ayes.
ayes.
Sorry.
Great, thank you. So, motion didn't pass. Thank you. So, file number 12040, is that 12041 and 12042? The complainant has left, and due to her disability, she asked for a continuance of her cases till next meeting. So I have to do that. DC3, do I need to take a vote on this? Do a motion and a second on this? On each
All the
one?
items on the agenda have to be disposed of through a motion. So you should
Okay.
take each item separately. There can be a motion and probably allow the respondent to speak about the motion.
Perfect, thank you. So let's start off with file number 12040. Madam Clerk, can you just read the first part of it?
File number 12040, complaint filed by Anonymous against Robert Collins, Deputy Director, Rent Board, for allegedly denying a request for reasonable accommodation of Rent Board Commission meetings.
Thank you. She has requested a continuance. Is there a motion to continue this?
So moved.
He's here. So you have to do the motion and then.
Oh.
So, do I have a second?
Second.
Second.
Great. It's been moved and seconded to continue this item. Is the representative for the Rent Board, Robert Collins, here? Hi. Would you care to comment on this continuance, or otherwise we're going to just move it to next month's meeting?
Just a brief comment. It would have been, I think, nice to know that as soon as he knew that, if that would have been
Well, she just
possible.
gave us you saw her here at the beginning. We just got the note from her that she passed because she was feeling ill. So after the beginning.
No other comment.
No other comment? Thank you. I apologize. If there's no other comment, then is everyone...
I'm a little confused because she put in a request and then withdrew the request. And I mean, I don't know, like, people are sitting here all evening, and we dealt with this at the beginning of the meeting, and we have a backlog, and so I just don't, I mean, of course, I would like to,
DC3, can you address this, please?
Through the chair, to Member David, I certainly understand your concerns around that. There are some unique aspects of this request as well as the original request. Anonymous, in her request, said that she needed this continuance to make a reasonable accommodation. So she has a limited mobility issue and has previously identified some aspects of that make it difficult for her to sit or stand for long periods of time and wait. And that was the reason for her original request that her items be moved to the beginning of the agenda. She then expressed, in response to my comments when she asked to rescind her request, she said, well, she thought that probably they would go quickly, so it wouldn't take a long time. Well, as it's turned out, it has been some time. So in an abundance of caution, I think it's best to grant the request.
Is it possible that we can, in granting this request, that we schedule her?
Well, hers will be at the top because
they
will be because we're going to flip them and they will be the top three.
There's one before.
So,
Also, the other, the original request for accommodation for her items in this meeting came after the agenda was set. If it had come prior to that, they could have been scheduled at the first in the original agenda.
Okay.
So can we put forward a motion that
well, we have a motion on the floor for 12040 to continue this item. The respondent spoke, so we need to take a vote. If everyone's in agreement, yeah, we should do a roll call vote. Yeah, just in case.
Member Monet?
Excuse me. Aye.
Monet, aye. Washburn?
Aye.
Washburn, aye. Sims?
Aye.
Sims, aye. David?
Aye.
David, aye. Highland?
Aye.
Highland, aye. Oka?
Aye.
Oka, aye. Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
You have 8 ayes.
Great, so the motion passed. We will continue file number 12040 to the March 6th meeting, March meeting. Next item on the agenda is file number 12041, complaint again by Anonymous against the Human Rights Commission for allegedly continually delaying a response to complainant's case investigation. Do I have a motion to continue this? She has asked that this item. Yes.
Madam Chair, because the respondent's represented by the same person in this matter, you might want to consider the two items together.
Oh, the following two.
Yes.
You're representing 4-1 and 4-2. Thank you. Okay. So for file number 12041, 12042, they've both been requested to be continued. Can I get a motion to continue these two items?
So moved.
Okay.
Seconded. There you go.
Okay, great. Member Oka and Member David seconded. The respondent.
Good evening, task force members. My name is Melaine Ahern. I'm representing the Human Rights Commission in both of these matters. And I want to put forth a formal objection to the continuance of both of these matters. Obviously, we've been here for over 4 hours now. And furthermore, the complaint itself being brought to the task force is disingenuous. It's an intent to utilize the task force for as a mechanism by which to achieve an objective for a different administrative end than the complainant was able to achieve through our process. The Human Rights Commission has repeatedly responded in a timely manner to all of the requests made by the complainant. The statement of facts for both these agenda items are the same, and we've provided all of that information time and again to the Sunshine Ordinance Task Force as well as to the City Attorney's Office. And it's resulted in a colossal waste of time and resources for the office. I have additional copies of all of the information that we've been providing to the various complaint mechanisms utilized by the complainant, and I request that these documents be reviewed. They've been sent to you electronically as well, and that both of these matters be dismissed. Thank you.
Thank you. There's no more comment. I'd like to take a vote on the motion to continue these two cases to the March 6th meeting.
On file number 12041 and file number 12042 to continue to the March meeting, Member Monet?
Aye.
Aye. Member Washburn?
Aye.
Washburn, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Chair Grant?
Aye.
8 ayes.
Great. So that's it. So we have on the agenda, guys, items 10 through 16 to approve the minutes. I'd like to suggest that we move that to the next month's meeting, unless you guys, I know, we're never going to get to it.
That since
I
May
know.
here. Maybe we should have a special meeting just for minutes.
Yeah.
Do it.
Sure.
Would it be possible to consolidate those two agenda items for the meeting in March in the interest of time and your time and ours at the Human Rights Commission. As I mentioned, it is the same exact set of facts that we're looking at.
DC3?
Through the chair to members of the task force, so long as the alleged facts are common and there's no distinctions between the actions of the two respondents and how they dealt with it, then it's perfectly acceptable to do that.
Okay. Thank you. So we'll make note and do that for next month's meeting.
Thank you.
Thank you so much for your time. I know she was sick. So that's my suggestion. If there is a motion to, well,
Do we have to do
do I have to do, DC3, do I have to make a motion for this approval to move the minutes to March's meeting?
All the
Yes.
agenda items have to be
Yes.
acted on in some way.
Can I group them all together?
You can move them all to be continued at the same in the same motion. Yes.
Okay.
Before you make that motion,
Yeah, I'm not going to make, I can't make.
I was just going to say, I can't remember the last time there are minutes on the website, and I was looking for minutes of the last one. So
They're on there.
They're up
You
there.
have to-
It's
yeah.
tricky. It's a little
hard
tricky
to find them. But-
It took me about a couple months to find them.
Yeah.
When I first
Me too,
started.
yeah.
Yeah. So then, for the next one, everyone will have looked at them so that we can do that. So do I have a motion to continue all these, to continue the minutes from May 2nd, 2012, all the way through January 16, 2013 meeting?
items 10 through 16?
Yes.
So moved.
Second.
It's been moved and seconded.
Without objection.
Without objection. Great.
Thank you.
And I think,
And we've got
oh, I see.
reports.
Reports. I didn't see that. Okay. I'd like to move, I'm not going to move, but I'd like to suggest that we move these items. I didn't see that. 17 through 19 as well, to continue to the meeting in March. Do I have a motion on the floor?
So moved.
Can I get a second?
Second.
It's moved and second. Great. So if there's are there any announcements, comments? Anybody wants anything for the next meeting? If not, then
Stay healthy, everyone.
you set the agenda, right?
yes.
Okay.
Yes.
Note that there was no one for public comment on this item.
Public comment.
Public comment?
I don't think there's anyone here for it, but you should note for the. Okay.
No, that's my mom. She's not. Mom, did you have public comment? Yeah.
It's time to go.
This meeting is adjourned.